Sorry, guys. There is some tech issues happening today all over everywhere, realistically. Okay. X is having issues. Chat GPT, Cloudflare itself is having an outage. Wow, my brain today. It's having an outage. So it is knocking things down, including down detector this morning. So there's a bunch of stuff that's just not working. And so I foresee these tech issues. Let me get the trial pulled up for a second here. It's still not on, which is weird. Hold on. Let me see here. They did have video at some point, and then they had the court room like way back, like maybe 8 minutes ago or so, and now it's just doing this. But this is where it's gonna be, so we're just gonna have to hang in there with this. Oh, that sucks, Benny. I'm sorry. Well, you can always replay it. That's the beauty of it. But so yeah, X is having a problem streaming to X from StreamYard. They're having my phone having an outage. So I'm trying to just put the link on X for us here on YouTube because otherwise people don't know we're live from there. So I'm just gonna tell people with the post. It's a known problem. Obviously, StreamYard sent me like a warning when I tried to connect. Because when I stream to multiple platforms at once, right? I'm not just on YouTube. I'm also on Facebook and X at the same time. So I can tell by the numbers I'm looking at on my screen that many people are missing. And I'm guessing that is because of this outage and they don't know. Hold on. I know. Here's an excuse. I have diarrhea. I shit myself. That's your excuse. Yep, it's a global problem, Christy. You are 100% right. Cloudflare is a DDoS service it's really for like rerouting, so people don't like just tag your IP address and find where you live and whatever. And a lot of companies use it. A lot of companies use it for privacy reasons, right? And for safety reasons. And so there is a global outage with Cloudflare right now. My chat GPT is not working at all. And that's where I do a lot of fine tuning. For certain things, like I'll make thumbnails that way, although sometimes they make them too big, so I have to like shorten them. But I sort of type in what I want it to look like, right? And then Chat GPT will download an image. From that image, I can then tell them, I can type in like change the color here, put these words there, take out the mountains in the background and just put a lake, you know what I mean? And so I do a lot of work with Chat GPT doing things like that, optimizing my hashtags for YouTube so they're more viewable. Because I'm a small channel, it's really hard to have people find you when you're just a teeny tiny channel. The algorithm is not optimized for tiny channels like me, right? So in that case, I have to do extra work to be seen, right? And even that is, it brings in a tiny bit of viewers, and so when that was down this morning and I only had 15, not even 15 minutes, I think it was 12 minutes to get ready for this, I was freaking out. I'm like, what am I supposed to do? Then StreamYard, I sign on to StreamYard and I just typed in a small description. I'm going to have to fix it later, just redo it later is what my plan is. Just typed in a small description. Otherwise I'd have to do everything by hand. It would take more than, 10 minutes. I didn't have that kind of time. So, like everything I have is saved, like all of my donation options and all that stuff that is saved into Chat GPT. So I can say, please write out all of my donation options and it'll write it all out. And all I have to do is copy it and put it in and change whatever I need to change, right? Add whatever I need to add, change whatever I need to change. If it makes a mistake, fix it, whatever. I can also ask it what are trending keywords on YouTube, right? That people would be looking for. Like that, there's, benefits in using some of these technologies. And I pay for the version of it, obviously, to help me do that. If I was a large channel, maybe I wouldn't need that, but I'm not. And so I got to figure out any other way to sort of bring in viewers, right? Like viewers who don't know we exist and want to be part of our community, but they don't even know we're here, right? Sorry, I'm just like re-putting my hair up because I did not have time for that. But this is what I mean. So there is a huge outage all over the internet. Down detector is down. What down detector is the thing that tells you if other things are down. So if like, for instance, you're using your Cash App card and it's declining and there's money on there, the first thing most people do is you go to down detector, www.downdetector.com, and you go, oh, hey, is there an outage? Is Cash App having issues? Same with Venmo or Chime or PayPal or anything, right? And you're like, oh, are they having any issues? Like, so down detector right now is currently down. None of the like donation or payment apps are down that I've seen yet, but down detector is down because Cloudflare is a part of that. So there is a bunch of techie issues running around all over the internet today. So just be aware. Ow, I just scratched my ear. Just be aware that you may run into, watching anything today or surfing the internet. Like you may run into some of these issues today with different websites and things, and just know it's not your computer. Your computer is not magically glitching out on you. It's not you. You didn't do anything wrong. It's Cloudflare. At the moment, that's what's being reported. I'm always skeptical of if it's actually a tech issue per se, or is it a cyber attack, right? I'm always very skeptical of that because, I mean, come on. Countries who don't love us in the United States or, our allies, in the UK or, any of our allies, cyber attacks are pretty common in trying to hack things, controlling things, changing things, getting information, that kind of stuff. So it doesn't shock me, does not shock me. This is my stressy, depressy, sick, I don't feel good, bun in the hair, don't really care look this morning. So don't judge me. Don't judge me, y'all. I'm tired. My stomach, it was literally eating itself this morning. Like literally. It's like, and I'm like, oh my God, my stomach is killing me. And I know I'm sick, but I can't put my finger on, is it my new meds that make me sick? Is it being sick on top of that? Like, I just don't know. I don't know. So yeah, I'm putting on YouTube, yeah. Twitter. Hold on. No, boy, listen. All right, these grays, they're going to be gone in just a few days, but still, I'm looking crazy this morning. I'm looking a little crazy. All right. Right? Time to come home. DC, speaking of DC, you can't even walk around DC nowadays. Nowadays, the cops are literally on the street corners with their machine guns in DC. Thank you, Sarah. I appreciate that, you guys. I do, but I know when I'm looking rough. And today I'm looking rough. Just saying. All right, so I'm putting the link to our live. We are live now. I'm just going to put the YouTube link on my X account. That way people can find us and know that we're live here and on Facebook instead of X this morning. It's unfortunate that there's so many issues because it looks like it's affecting. X is telling me I can't retrieve my messages. Like it's a whole rigmarole right now, and I don't know what the hell is going on with this. Let me see if I can pull up another channel that is doing the trial. I mean, I don't know why they went to this thing, WCBB. But they're the ones who have been covering it. So let's see. It turned black. Okay, maybe we're getting somewhere. I don't know. I don't know. Or not. Or not. Is your Zoom for work, Benny? Is that what it's for? Zoom for work? So many tech issues. And that's the other thing. I don't think people got notifications this morning either. So just know today, it's not you. It's the tech. It's the tech, folks. It's the tech. It's not you. Oh, yeah. Yep. Ugh, those are the worst. You can't even come up with an excuse for those. I go to my doctor once a month. It's fucking obnoxious. I mean, at least it's Zoom though, right? You don't have to physically be there, which is nice. You know, I do my therapy not through Zoom, but it's virtual. Lots of tech issues this morning. I can't access certain things. Oh, here we go. All right, this is good. Oh, I might want to unmute that, right? We might want to do that. Oh, it is unmuted. Holy bagoli. My brain is in like DTD mode today. Okay, well, I'm waiting for this audio. Hello, can we get some audio? It's funny, Benny, because other people didn't get the notification. You got the notification, but other people didn't get the notification we were live. A lot of people didn't.
Make many mistakes.
Here we go. Get some audio. I gotta grab a water, guys, because I am super dehydrated.
Yeah, no worries. Hey, Jimmy. Yes. I just printed something off the printer, but it's not in my pile, so I have a feeling, which was I added that question that you just asked me to add. Okay. Can you just check my printer to see if I printed it out and didn't bring it out?
If I was him, I would know, Dougie, that I'd be screwed. How are you, by the way, my darling? I haven't seen you in a while. I've seen your comments, which I love, by the way, on the videos when you're catching it. But I haven't seen you in a while. Miss you. See, Sarah didn't get the oh, you didn't get the notification. Oh,
We'll take a break.
somebody must have bought memberships to JFK's stream because I got one in my email saying that I got a gifted membership. Somebody must have been gifted memberships over there last night. Well, I mean, they do almost every night, but you got notified? Interesting. A lot of people didn't, obviously. I'm looking at the numbers right now and I'm like, okay, because X isn't working, there's not a ton of you here. And so I'm like, a lot of people, A, didn't get notified. Jessie said she didn't either. And B, Yeah, the time change is kicking my booty. Graves said the same thing. I'm telling you, it's just not. It's some of us are like, it doesn't usually affect us, but it did this time. The time change. It's only an hour, but you know. Yeah, I'm telling you. I'm hearing that from a lot of people. Not just us. I'm hearing it from a lot of people. Oh, Cloudflare is down. Somebody is saying X isn't loading. I don't even know if me making that post even helped, to be honest, because if it can't even load, you know. Yeah, I mean, I wasn't even on last night. I'm just so what happens is when you're a subscriber of that channel, when the computer runs out of people to give it to who are there all the time, it starts giving it to just people who are subscribed to the channel. And because I was subscribed to the channel,
Yes, please.
Your Honor, this
I
is
got
docket
one.
number 23CR.
X is down completely? Like completely down?
Mr. Walsh is present. Can I have counsel identify themselves for the record?
Oh, man, that's no good.
Morning, Your Honor. Greg Conlon, Commonwealth. Morning, Your Honor. Tracy Cusick for the Commonwealth.
He should be
Good morning,
terrified.
Your Honor. Ann Yaz for the Commonwealth.
Welcome to the prosecution and to the defense.
Damn.
Good morning.
Good morning, Your Honor. Good morning, everyone.
So
Kelly
me making
Porges
that
on
post
behalf of
didn't
Mr.
matter.
Walsh.
Morning, Your Honor. Larry Tipton for Mr. Walsh.
Welcome to all the lawyers and good morning to Mr. Walsh. Before we get started with today, I'll see you at the side of the bench.
Yeah, it didn't do it. Didn't post it. Damn. Morning. That's good old Jesse telling you guys in Discord. Thanks, Jesse. Appreciate you, my friend. They start with a sidebar. I love how she says, not sidebar, but she says, I'll see you at the side of the bench. Well, Your Honor, sure. See you at the side of the bench. Not, it's a, you know, sidebar, but we'll see you at the side of the bench. Interesting. I'm going to keep an eye on X and see, you know, what the hell is going on, because it looks like it doesn't even matter that I made a post to tell people. It's just not working at all. Yeah, it's not loading. It's not doing anything. Just keeps telling me there's a issue. Let me see if I can do it from my computer and see if that makes a difference. Okay, someone got a post through about 11 seconds ago, so I wonder if I could do it from my computer. Let's see. Let me see if I can do it this way. No, not at all. I mean, I literally had like 10 minutes, you know, after I got my kiddo on the bus. That was me rushing around like a maniac this morning, trying to get this done. And then all the things being down did not help me. Massive Cloudflare outages affecting X, Chat, GPT, and even Down Detector. Cloudflare, a networking company that provides DDoS protection, like I was telling you guys earlier, and delivery services for many companies around the globe, is experiencing a major outage that's taking down sites across the web. Users are running into error messages when they try to access X, Chat, GPT, and even the outage tracking website Down Detector has an error message saying, please unblock challenges.cloudflare.com to proceed. That's exactly what ChatGPT said. That was the exact same message I got on ChatGPT. And I was like, I don't have Cloudflare. So why is it? So then that's when I went to go look into it. When I'm like, I don't use Cloudflare. There's other things you can use. And I'm like, I don't use Cloudflare. So what the, and I obviously know what Cloudflare is. So I'm like, what's actually going on here? No, it is pretty obvious he's guilty. I haven't yet run into somebody who said he wasn't guilty. It's not that this case is a big, it's a big deal because it's kind of a interesting story, right? He was already on like federal probation for, well, it is a trial stream, but oftentimes when issues come up, we talk about those too. And right now there's a issue affecting X and other websites. Cloudflare is having a global outage. So I was explaining to people what's going on with that, and it's not their computers this morning if they're having issues. No, not just that, it's close to home. So the case is interesting. He was already dealing with a case where he was on a GPS bracelet. Well, it wasn't a GPS. It was a monitoring bracelet, but it wasn't GPS. So basically, it was one of the bracelets that like you can only go so many feet from home, right? Or it goes off. And you have to be home at certain times, otherwise it would go off, right? So that was for like selling fake art, right? And so he was dealing with that case when the wife went missing. Now she worked in DC and would come and go from where they lived here in Massachusetts to DC with her work, right? And so she came home but was late for the holiday because her plane had been delayed. And so she drove instead, right? So she didn't get back until afternoon on Christmas Day instead of flying in on Christmas Eve, right? So there was an argument about that, right? Then she went back to DC for work, okay? And then on New Year's Eve, they had a friend over. They had this little sort of dinner party, I guess. The friend left, he said, I think 1:30 a.m., around 1:30 a.m., and she was never seen or heard from after that. Now, Brian Walshe told everyone she took an Uber back to the airport for a work emergency, but that work emergency did not exist, and they found no records of any Uber. So fast forward, they found surveillance footage of him in a Home Depot buying like $400 to $450 worth of like cleaning supplies, a hacksaw. Like they found bloody X, Y, and Z in a dumpster near his mother's house. They found her purse, her ID, her necklace, her watch, but not her, right? He did a lot of really creepy searches on devices in the house, including the kid's iPad, I believe. And some of them were like how to embalm a body, how to handle remains, some really seriously concerning searches, right? So I've yet to see somebody say they don't think he's guilty. That's my opinion of it, is, with the evidence we have now, but of course there's going to be much more at trial. But my early opinion obviously is I think, in my opinion, he's guilty, right? But I have yet to hear someone say they thought he was innocent with all the evidence that's pretty stacked up on him. It's just an interesting case. They were an upper, middle class family with children. There was some talk about him sort of forging something in his dad's will or something along the lines of the dad's will. So she came, I think, if I look correctly, hold on. I think she's originally from Serbia, I believe. Let me see. I have a timeline. Bye, Dougie. Have fun at work, my friend. As much fun as you can have, my friend. See you in a half an hour, Benny. Let me see.
Okay.
Yeah, some of the Google searches were like dismemberment, things like that.
Everyone else set?
Messed up.
Yes, Your Honor.
Thank you.
May I proceed, Your Honor?
You may.
Mr. Walsh, can you please stand?
Oh,
Mr. Walsh, do you wish to offer a change of plea on docket number 2382CR91002, which charges you with intimidation of a witness, juror, police, or court official, and 003, disinterment of a body? Do you wish to offer a change of plea from not guilty to guilty?
I do.
Could you raise your right hand, please? Do you solemnly swear to make true answers to such questions that should be put forth to you by the court, so help you God?
What?
Thank you. Could you please take the witness stand?
He's taking a
Actually, you know
plea?
what I'm gonna, this is an odd configuration. I don't want counsel standing. So I'm gonna let you stay right there, sir. You understand you're under oath?
I do.
All right. Why don't you be seated and you can have the benefit of your counsel at the ready right there.
Okay.
What is happening? Why am I hearing
Mr.
it
Walsh, as you know,
twice?
my name is Diane Frenier. I'm the judge that's presiding over this trial.
Are you guys hearing
And
this
I'm an
too? What's
associate
happening?
justice of the Superior Court in Massachusetts.
No, it's only on that
I
one
understand
case.
from your lawyers that you wish to change your plea to guilty to counts indictment 002 and in 003. And before I can accept that change of plea to guilty to those two indictments, I need to ask you some questions to make sure that your decision
I
to
can hear
plead
it
guilty
twice.
is made voluntarily and that you understand the consequences of pleading guilty to those two offenses. If at any time during the course of this colloquy, you don't understand something that I am saying to you, just let me know by letting your attorneys know. Let them consult with you. And equally, if I don't understand something that you're saying to me, I'll ask for that further clarification. Do you understand, sir?
Yes, Your Honor.
All right. Can you please state your full name, sir?
Brian Walshe.
All right. And Mr. Welsh, do you have any difficulty speaking or understanding English?
I do not, Your Honor.
How old are you, sir?
I'm sorry, I missed that.
Sure, I'll try to get into this microphone. How old are you?
50.
And
Hold on a second, guys. I'm sorry. I have to pause that for a second because I am literally hearing it twice in my ear and I don't understand where the second one is coming from. I just want to shut that second one down here. I know it's fine from your end, but I can't even concentrate because it's. Hold on. You know what? Like it is. Hold on. Give me 1 second. Let me refresh this real quick. What is happening in my world right now?
Carnegie Mellon,
what did you study?
business and computer science.
It's so strange to me. I
As an
can
adult, have you had
still hear
full-time
it in my
employment?
ear. I don't understand where it's
Uh,
coming
I've had
from.
my own businesses,
And in what kind of businesses?
mostly consulting.
Okay. I need to ask you some personal questions. I'm going to ask you those questions now. Have you ever in the past been treated for any mental illnesses or conditions?
Yes,
Tell me about them.
depression.
And are you aware of whether anything else other than depression?
That was the main thing.
All right.
Okay.
And are you presently
Better.
aware of whether you have any mental illnesses or conditions, to include depression?
No,
Fix it.
Are you taking any medications?
no,
In the last 24 hours, have you taken any drugs, legal or illegal?
no,
In the last 24 hours, have you consumed any alcohol or alcoholic beverages?
no.
Is your mind clear here today?
Yes,
Tell me in your own words, sir, why are you here
I'm here to plead guilty.
on those two counts?
Yes,
And you understand that your trial's starting today?
Yes.
On the first indictment? All right.
Interesting.
To defense counsel, have you had any difficulty communicating with your client?
no,
No, Your Honor.
And do you believe that he has
Thank you,
understood the
Christina.
advice that you've provided to him?
Same.
So at this time, I'm going to go over what's called the waiver of rights. And at the end of it, I'm going to give you the form back that I believe you signed earlier today. Do you understand, sir, that by pleading guilty, that you're giving up your right to have a public, fair, and impartial trial?
Morning,
As
Lisa.
to each of the 2 indictments to which you're now pleading guilty, with or without a jury, to determine your guilt or innocence?
I do, Your Honor.
And do you understand that if you went to trial, you wouldn't have to prove anything? For example, you never have to take the stand to testify. You would never have to call any witnesses. No jury could ever hold it against you if you did not present any evidence at all. Instead, it is the Commonwealth that has the burden to prove you are guilty of each of the offenses and each element of those offenses beyond a reasonable doubt. Do you understand that?
I understand, yes.
You have the right to be tried by a jury of 12 people selected from your community, and you would have the right to participate in jury selection. You could not be found guilty unless the Commonwealth convinces all 12 jurors that you are guilty beyond a reasonable doubt, and they unanimously agree you are guilty. Do you understand?
Yes, Your Honor.
You also have the right to be tried by a judge instead of a jury. And again, the judge couldn't find you guilty unless the Commonwealth presented evidence sufficient to convince the judge beyond a reasonable doubt that you are guilty of the charge. Do you understand?
Yes.
Do you understand that if you went to trial, you would have the right to confront your accusers and any other witnesses that may testify against you by facing them and having your attorneys ask questions of them?
Yes, Your Honor.
And do you understand that if you went to trial, you would have the right to call your own witnesses, present
not
your
innocent.
own evidence, and if you wished,
Who said he
even
was innocent?
testify on your own behalf? Do you understand that?
Once again, in my opinion, he's guilty. Who says he's
Do you
innocent?
understand that by pleading guilty here today, you're giving up your right to pursue any arguments or motions that your attorneys may have made or filed on your behalf in this case, and that may include motions to dismiss and motions to suppress, as well as your right to appeal any rulings or decisions that the court may have already made in this case?
Yes, Your Honor.
And are you willing to give up each of those rights?
Yes, Your Honor.
Pass that to the defendant.
Ah, interesting, Lisa. See, maybe that's a good little.
Sir, if passed, had the court officer pass to you defendant's waiver of rights, have you seen that form before?
Yes, Your Honor.
And did you read that document or have someone read it to you?
Yes, Your Honor, I read it.
Have you reviewed it with your attorneys?
Jeez.
Do you understand it? Do you understand what's contained on the waiver of rights form?
I do, Your Honor.
You understand that that form sets forth in writing what you and I have just been discussing a moment ago in terms of your willingness to waive your constitutional and statutory rights and plead guilty to the 2 indictments.
Yes, Your Honor.
Is that your signature at the end of the document?
Yes, Your Honor.
And did you sign that voluntarily?
Oh, for the love of God, that's the dumbest thing I've ever
By
heard in my
signing that
life.
form, you're confirming to me, sir, in writing that you are aware of the rights explained on the form.
Yeah,
that you
they're
understand them,
blackmailing
and that
him.
you voluntarily waive them. Is that correct?
Yes.
One is to the witness intimidation, and I couldn't quite hear the other one because it was double going in my ear, but I don't think it's only 2 of the charges. Cops definitely didn't get the wrong man on this one.
Do you understand, sir, that you are pleading guilty to the following
point.
2 indictments? Indictment 002, which charges willfully misleading a police investigation, a criminal investigation, in violation of Massachusetts General Laws, Chapter 268, Section 13B, and in Indictment 003, you are pleading guilty to, while not being lawfully authorized by proper authorities, willfully conveying away a human body or the remains thereof in violation of Massachusetts General Laws, Chapter 272, Section 71. Do you understand that?
Yes, Your Honor.
And have you talked to your attorneys about each of these two indictments?
Yes, Your Honor.
Has counsel explained the elements of each of those two indictments that the Commonwealth would have to prove beyond a reasonable doubt?
Yes, Your Honor.
Do you understand each indictment?
I'm sorry, what did you?
Do you understand each indictment?
Yes, Your Honor.
And to defense counsel, have you explained the elements of each of the two offenses
He's
to your
pleading
client?
guilty.
I'm going to ask that the assistant
looking
of
up
the
the
Commonwealth,
ones
whoever
right now.
wishes to do it, would tell
The
me
two
what
of the
the
indictments.
maximum and minimum sentences are.
right,
And I don't believe
Anderson.
there are any mandatory minimum sentences, but you can
Oh,
tell
for
me
the
if
love
there
of
are.
God.
There
Yeah, so
are
all
no min-
murderers
there
are
no mandatory
innocent.
minimum sentences,
Got
Your
it.
Honor. The maximum sentence on count 2 is 10
Right.
years unless the investigation is into a capital offense, and then it is a 20-year sentencing enhancement, up to 20 years. On count 3, it is up to 3 years in state prison.
Thank you. Mr. Walsh, did you hear the maximum possible sentences for the charges that the Commonwealth just recited?
Yes, Your Honor.
Right.
Would you
Yes,
not
Your
be
Honor.
sweating if you were in
Do you
a
understand that if I
trial
impose a
for
period
murder,
of probation,
whether you're guilty
you
or
will be
not?
subject to the terms and conditions imposed, including not committing any other crimes and reporting to your
witness
probation
intimidation
officer.
and disposal of the
Yes,
body?
Your Honor.
So how do you?
If you should later be found in violation of any
Bernie?
of the terms or conditions of your probation, a judge could sentence you up to the maximum penalty allowable by law for any of the charges on which you have been found in violation of probation, and would be required to sentence you to any mandatory minimum penalty required by the law.
Yes, Your Honor.
Do you understand what I just explained?
Yes.
Pleading guilty has certain implications for you, and I'm going to go over those implications with you now. First is DNA testing. By pleading guilty to these two indictments, you will be required by law to submit a sample of your blood,
No,
hair,
he's not
and or
pleading to the
saliva,
murder.
and that
Doesn't look
sample
like
will
it.
become part of the Massachusetts DNA database. You will be required to pay for the cost of collecting, preparing, and processing that sample unless you are determined to be indigent, and failure to comply with this law will subject you to separate criminal penalties. Do you understand?
Yes, Your Honor.
Are you still willing to plead guilty?
Yes, Your Honor.
I know earlier in the colloquy this morning, you told me that you were born in Boston, and I have no reason to doubt that. But the law mandates that I give you warnings with regard to immigration consequences, and I'm going to give you those immigration consequences now. If you are not a citizen of the United States, you are hereby advised that my acceptance of your
don't know
guilty
this
plea
case?
may have the
Brian
consequence
Walshe.
of deportation, exclusion from admission to the United States, and denial of your naturalization request, all pursuant to the federal laws. Further, if the offense to which you are pleading guilty is under federal law, one that presumptively mandates removal from the United States, and federal officials seek your removal, it's practically inevitable that this conviction will result in deportation, exclusion from admission to the United States, and or denial of your naturalization request, again, under those federal
No.
laws. Do you
He's just
understand what I
pleading guilty
said?
to the other two.
Has your attorney advised
For
you of
whatever
these
reason.
consequences if you are not a citizen of the United States?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
They're not dropping anything.
Because the sentence for count number 2 could be a sentence, a state prison sentence of 3 or more years, I'm now going to give you what's called the
Yeah, bizarre is
habitual
right.
offender law warning, which I'm required to give you. Here it is.
You're a
If at
habitual
some time in the
offender.
future you are convicted or plead guilty to a third or subsequent offense that is within the category of offenses covered by the statute, then 1, you may be imprisoned in state prison for the maximum term
Murder.
provided by law for such third or subsequent offense.
He unalived his
2,
wife.
your sentence could not be reduced or suspended. And 3, you may be ineligible for probation, parole, work release, or furlough, or to receive any deduction in the sentence for good conduct. Do you understand what I just said?
Yes, Your Honor.
And understanding what I've advised you with regard to these sentencing consequences, are you still willing to plead guilty to the 2 charges?
Yes, Your Honor.
Yeah, lots of it. It was supposed to just be Jerry's election. This was a surprise to everyone. That's what it was supposed to be.
All right. I'm now going to ask the Assistant District Attorney to summarize the evidence that would have been presented against you by the Commonwealth if you went to trial in this case. I'm going to ask, sir, that you listen carefully, because when the ADA is finished, I'm going to ask you some questions about
Agreed,
the
Emily.
facts that the ADA
Agreed.
has stated.
Thank you, Your Honor. Your Honor, regarding count 002, misleading police in violation of Mass General Laws, Chapter 268, Section 13B. On or about or in between January 1st to January 8th, 2023, Mr. Walsh did willfully mislead police officers with the intent to impede, obstruct, delay, prevent, and otherwise interfere with the criminal investigation into the disappearance and murder of Anna Walsh. The defendant first misled with Cohasset police in the morning of January 4th, 2023, when after he had reported his wife Anna Walsh missing. He stated to a Cohasset police officer that Anna Walsh had left the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset on the morning of January 1st, 2023, by taking an Uber or Lyft to Logan Airport when returning to Washington, D.C. for a work emergency. The defendant then continued to mislead police officers when he made additional false statements about Anna Walsh being alive and voluntarily leaving the Walsh residence, as well as when he detailed his whereabouts on January 1st, 2023, to Cohasset police and Massachusetts State Police officers. The defendant continued to make false statements when the police officers from these agencies met with him, including on the evening of January 4th, on January 5th, January 7th, and January 8th. In January of 2023, the Cohasset Police Department had approximately 20 full-time police officers, including 2 detectives. The Cohasset Police devoted all available resources in an attempt to find Anna Walsh. They requested assistance from other departments and agencies. And on January 6th, the chief of the Cohasset Police Department conducted a press conference seeking help in locating Anna Walsh. As a result of the defendant's false and misleading statements, law enforcement agencies and police officers took many actions, which had a heavy financial and emotional cost. These included the Cohasset Fire Department searching a swimming pool at the Walsh residence, teams of police officers from multiple agencies and departments, including a K-9 teams participating in large-scale canvass of the area around the Walsh residence during inclement weather. D.C. Metro Police attempted to locate Anna Walsh in Washington, D.C., and Massachusetts police officers, including Cohasset Police, Massachusetts State Police detectives, and other units from the Massachusetts State Police traveled to Washington to search for Anna Walsh in a result of the defendant's false statements. The defendant's conduct was willful. His statements impeded, obstructed, delayed, and otherwise interfered with the criminal investigation, and the delays resulted in the contents of dumpsters in which the defendant had disposed of Anna Walsh's remains being incinerated.
Why don't you pause there? We'll deal with count 1 and, count 2, and then we'll go to count 3.
Yes, Your Honor.
All right? So, Mr. Walsh, did you hear what the Assistant District Attorney just said with regard to the statement of the offense conduct for indictment 002, misleading police?
Your Honor, if I may, Mr. Walsh is prepared to admit to the recitation of facts with respect to the indictment that the government just read, insofar as it alleges he did impede and obstruct the criminal investigation into the disappearance of Anna Walsh. We obviously object, and he's not admitting to and murder. The second portion of the facts that the government just read that we would take issue with is the last sentence, and the delays resulted in the contents of the dumpsters into which the defendant had deposited Anna Walsh remains being incinerated. Insofar as the rest of the facts, he's prepared to admit.
All right. Mr. Walsh, you just heard what Attorney Porges said, sort of the insofar as, it's another way of saying it limited to this. And you heard what your counsel just said. Understanding those limitations as just articulated by your counsel, did you do or join others in doing those acts?
Yes,
Do you understand that by pleading guilty that you're admitting to the facts described as revised by your counsel are true?
yes,
Are they?
yes,
Mr. Walsh, did you in fact willfully mislead various law enforcement to include members of the Cohasset Police
I'm glad
Department
you turned
and
it
the
on.
Massachusetts State Police with the intent to impede or interfere with a criminal
I love that for
investigation
you.
of Anna Walsh's disappearance?
yes, Your Honor.
All right. Moving to indictment number 3.
Thank you, Your Honor. Willfully conveying a human body in violation of Mass General Laws, Chapter 272, Section 71. On or about and in between January 1st and January 8th, 2023, the defendant Brian Walshe willfully conveyed away the body of Anna Walshe or the remains thereof from the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset by conveying and disposing of Anna Walsh's body without a license or lawful authority or the remains thereof into dumpsters and or garbage receptacles in eastern Massachusetts. The defendant's actions were willful. Anna Walshe was not a stranger to the defendant. She was the defendant's wife and mother of his 3 young children. The defendant conducted internet searches into disposal of the body, researched locations of dumpsters, and then traveled to those locations. In disposing of the body of Anna Walshe, the defendant did not comply with the law.
Thank you. Sir, did you hear what the Commonwealth just alleged it would prove the case went to trial with regard to indictment number 3?
Yes, Your Honor.
And did you do those things or join others in doing those acts?
Yes, Your Honor.
Do you understand that by pleading guilty to today, you are admitting the facts described just now by ADA Connor?
Yes, Your Honor.
Mr. Walsh, did you in fact willfully
He's still got to do the
remove or
trial for
convey
murder.
the body of Anna Walsh or her remains, not being lawfully authorized to do so?
Yes, Your Honor.
Do you now plead guilty to these indictments willingly and voluntarily?
Yes, Your Honor.
Has anyone threatened you or forced you in any way to plead guilty to these 2 indictments?
No, Your Honor.
Has
No,
anyone
no
promised
dismissal
you
of the
anything in
murder.
return for your plea of guilty to these 2 indictments, other than the terms of the plea agreement that we discussed? Excuse
I'm
me,
with you
there's no
on that,
plea
Dave.
agreement.
No idea.
That's what happens when you keep reading from the book.
Makes
and
no
you shouldn't.
freaking makes no
Has
sense to me.
anyone promised you
Why?
anything in return for your plea of guilty to these 2 indictments?
No, Your Honor.
Have you had enough time to discuss your rights, your case, your defenses, and the possible consequences of your guilty plea with your attorney?
Yes, Your Honor.
And do you feel that Attorney Tipton and Attorney Porges have acted in your best interest, that he and she have fully, fairly, and adequately represented you in this case?
Yes.
I
Are
haven't
you
heard them say
confused
anything
in any
about
way by any of
the
the questions
dismissal of
I've
the
asked
murder
you
charge.
today?
So
No, Your Honor.
As I understand it then, sir, you're pleading guilty to these 2 indictments because you wish to plead guilty because you are guilty. Is that correct?
That is correct.
Counsel, do you know, defense counsel first, do you know of any reason why I should not accept your client's guilty plea?
You do not, Judge.
Same question to the Commonwealth.
Your Honor, I'll be brief, but we had this is a non-negotiated plea with the Commonwealth, and we had some objections to it. But my concern was where the defendant equivocates on the factual basis.
It
The
could.
Commonwealth read in that is one reason you should not take it. And the second is this count 3 revolves around improper disposal of Ms. Walsh's remains. And the defendant, when asked his marriage status, said that he was married. And consequently, Your Honor, then that is not an accurate relaying of his current status to the court and could be invalidating the plea. So I believe he has to be asked that question again. And I believe that if he continues to say he's married, that he's negating facts of count 3.
All right, I'll give defense counsel an opportunity to speak with your client.
Your Honor, I apologize. I couldn't exactly hear what Mr. Connor's caveat was.
In response to one of the early questions I asked of the defendant, I asked him if he was married, and he said yes, he was. And the Commonwealth was raising the point that if that were true, that it might negate proof of the disinterment, which requires a human body or remains. Do you want to speak to your client about that?
A moment, Your Honor.
So I haven't heard them say anything about dismissing the murder charge for this, which is why I was like, what are they fucking doing? I'm so confused here. Like, why would they?
Respectfully, I don't see this as a relevant or material issue. If the court wants clarification, I'm happy to approach sidebar.
Why don't we do that?
Okay.
Right. Like, just strike the question. It's actually not a necessary question to take the plea. What, you know what I mean? Like, this doesn't have to be difficult. Just strike it and call it a day. I mean, they could have just done that. It's as long as he's of sound mind, he's pleading guilty because he's guilty. That whether he's married or not, it's not something that's required to take the plea, you know, because he answers yes. Yeah, they just had the competency hearing. So I worked at that facility, right? He's pleading guilty, but not to the murder. Leah, not to the murder. That's the weird part. He's only pleading guilty to witness intimidation and discernment of a body. But why? If you're pleading guilty to moving said body, right? That kind of puts you in a pickle for a trial unless you're going to use third party or say someone was holding you hostage and made you do it. You know what I mean? Like those kind of defenses. I don't understand how you're going to defend moving the body. You know what I mean? That doesn't make sense to me. It does, but they do have to be relevant to the charge. But even if you try to take away his statements about moving the body, I think those could also still be let in because it's part of the murder per se. So that's where it gets a little tricky. That's where it gets a little tricky in my eyes, because I don't think that the judge is just gonna be like, oh, cool. Ted Daniels posted the pleading. Fuck Ted. All right. I just had to say that, but fuck Ted. I don't know what he was diagnosed with. He did have a competency hearing. I told you guys he would be found competent because I worked at that facility. I know how it operates. There's almost no one that's ever found not competent for more than like a couple months. You know, very rarely there'll be someone for a few years. And even more rarely it'd be, you know, more than a few years. No. The witnesses, are you talking about from yesterday? The witnesses are suing Karen and Aiden. Is that what you are talking about? Unless something else happened this morning that I'm not aware of. Because other people sent me the article that I was pointing out yesterday, and they're like, this is bad. And I'm like,
Mr. Walsh,
bad
earlier
what?
today,
The
I asked
witnesses
you
are
whether
suing.
you were married, and you answered yes, you were married. Do you
Oh my
remember
God,
that?
why is this such a big...
Yes, Your Honor.
And is it correct that you were married to Anna Walsh for a period of time,
Yes, Your Honor.
and that under the law, death extinguishes marriage? It may not religiously or otherwise, spiritually, but under the law, when someone dies or when someone is dead, you can no longer be married to them. Do you understand that?
Yes, Your Honor.
And so are you married today?
Your Honor, if I may, insofar as previous discussions, for purposes of a successful plea colloquy and meeting the elements of the crime, he is acquiescing to the fact that lawfully he is not married today.
All right, you heard what your lawyer just said? Agree with what your lawyer just said?
Yes, Your Honor, I agree.
All right. Anything else that we need to cover?
No, Your Honor.
All right. To the extent that the Commonwealth is objecting to the taking of the plea on other grounds, that is overruled. My job here is to make sure that I have a valid plea, and that means that the defendant is pleading guilty to the elements that the Commonwealth would have to prove beyond a reasonable doubt, and I have inquired sufficiently to assure myself that he has admitted to each of the elements of the two offenses of indictment 02 and 03.
Yeah, the kids break my heart, you know? Sad. I'll check what he has posted. In
So I know we discussed at an earlier point the issue of victim notification, and I'll ask on the record now for the Commonwealth. Does the
We do
Commonwealth
have a
advise
consciousness of
the
guilt
victims
instruction.
of this case, of the defendant's offer to change his plea to guilty?
Yes, we have notified the victims, Your Honor.
And based on our prior discussions, I understand that
It was a rabbit hole, too.
the victims may wish to
Oh.
address this court
I
prior
see,
to any
I see, I
sentencing of
see.
the defendant.
That is correct, Your Honor.
All right.
Oh,
And,
okay.
both parties, and we've talked about this,
Got
have
it, got it,
agreed
got
that
it.
we're not going to be sentencing the defendant today on the indictments that he's now pleading guilty to, correct?
That is
Got it,
correct, Your Honor.
Attorney Tipton, Borges? All right. And we'll give the victims a
Oh, I know that.
reasonable opportunity to address the court.
Former
before
criminal
sentencing.
turned prison
Thank you, Your
worker here. Believe me, I know. I know all about that. Especially if it's a lower sentence. I mean, taking the risk that
You
could be
understand,
found
Mr.
guilty.
Walsh, that at
People
the
do
time that we
plead
do
guilty
get
for
to
something they
sentencing,
didn't do.
that by
But-
law, I'm not bound to any
Well, that's the case
recommendation
here.
that's made by the prosecution or your lawyers. You understand that?
Yes, Your Honor.
And that I may impose any sentence permitted by law up to the maximum allowable sentence.
Yes, Your Honor.
Having considered Mr. Walsh's criminal history, the government's proffered evidence, I will later consider the victim's
Believe me,
statements to the court.
I've
for matters
thought
for
about it
sentencing.
myself way back when.
I find that Mr. Walsh has met the requirements to tender a plea to counts 2 and to counts 3. I make the following findings. I find that the defendant is not presently under the influence of drugs or alcohol, and that he hasn't reported that he is not presently suffering from any mental illness or condition, and that he's not presently taking any medications. I find that the defendant understands the nature of the charges and the consequences of his pleading guilty. I find that the defendant's change of plea to guilty with respect to each of the two indictments, 02 and 03, is made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge of its consequences. I find that the defendant's change of plea on these two indictments to guilty is made upon and with the advice of competent counsel, and I find there's a factual basis in the evidence as has been summarized by the prosecution and limited by defense counsel on behalf of the defendant for each of the two indictments to which the defendant now pleads guilty. Accordingly, I accept Mr. Walsh's plea of guilty as to indictments 002 and 003. Anything else that counsel that we need to do on the change of plea?
No, Your Honor.
All right. So let me turn to empanelment.
Believe me, if you're charged with a bunch of felonies and pleading out to the misdemeanors will get you out of jail and put you on probation instead of sitting in jail for 5 years, you'll plead out to those misdemeanors
each,
instead of
had an
a felony.
opportunity last night to
Happens all the
look
time.
at the,
Most cases the court
question, and
has
I know
are
that
plea
defense
deals.
Counsel asked for an additional question to be added. I did add that. All right, I do have the right version. Counsel, if you want to come up, you can take a look at what I added.
I've seen it time and time and time again. You know, if you have to weigh the options, right? If you have family and even if you're being charged with something you didn't do. I've lived that experience, being charged with something I didn't do. And they said, and I kid you not, right? They said, you can take a plea deal and we'll drop this to a misdemeanor, right? Or if you don't take the plea deal, we're going to find you, the judge said, because I was on probation, going to find you guilty on the felony, right? And I never forget this moment because I turned to my attorney and I said, I'm taking it to trial. I didn't do anything wrong and I have the right to a fair trial. I said, the judge can't just find me guilty because they won't take a plea deal. And I'll never forget my public defender's response to that. She turned and looked at me and said, he can do whatever he wants. He's the judge. And I turned back to her and I was like, no, he can't. Right. You know, we pushed forward with that. Thank God. But I did think about taking the plea deal at that point. But then I was like, no, F this. F this. I'm not going to be bullied into taking a plea deal for something I didn't do because they want me to. And that was before. So to get bullied basically by a judge? Like, what? Like, no. And they wanted me to take that deal. It was where you take this deal. And the judge said it in open court, or we're going to find you guilty of the felony that you're on probation for. I'm sorry, what? I have the right to take this to trial in a fair trial, considering they wouldn't be able, in my opinion, they wouldn't have been able to prove it without a reasonable doubt because there's a little police report saying there was a man on the roof. Like, I had nothing to do with it. It wasn't there. Like, you know what I mean? So, I wanted to take it to trial and my public defender was like, no, take the deal. And I was like, no, I didn't do it. But you do think about it. And some people do plea out where they're like, I'd rather plead the misdemeanor and stay on probation or whatever instead of going to jail. Our system's fucked, right? And especially, so imagine you go to jail for something you didn't do, right? And you're in jail. It's not designed to let you out, even if there's evidence proving that you're innocent. It could take decades or maybe never for you to come out of jail, even with evidence proving that you're innocent. I mean, that's a broken system, right? We know this. We literally know this. Oh, the co-defendants? Yeah. I mean, they do. They plead all kinds of things. I was picking up what you were laying down. It's definitely not, you know? But, you know. Yeah, B. Tim. Isn't that wild? Nobody that I know of thinks he's innocent, but a guy pled guilty to being a felon in possession of a firearm when he clearly was not, so that his brother... Me and the internet are going to fight. I don't see it a lot here in Massachusetts, but I've seen that in other states way more often. But I was picking up what you were laying down, even with the autocorrect and the voice to text. Well, when you're here from Massachusetts, that's why I don't use text to talk, because my phone says things that I'm not saying with the accent. It happens to me all the time. So I don't use it. I get sick of it. And I'm like, all right, that's not what I said. It's nice to see you, B. Tim. You're always welcome to pop in if you have a minute and give your thoughts. Well, while the court's taking a break, remember to make sure you get your memberships for the channel if you don't already have one, my friends. And if you'd like to help support my teeny tiny channel, you know, we have no corporate overlords, no sponsors, no other creators telling us what we can and can't say. We have truth bombs. That's what we bring. We talk about stuff that mainstream media won't talk about. We cover lots of cases. We talk about other random shit that's happening in the community. And we also check in on one another, make sure one another are all right, because that's an important part of a community, is making sure that the community itself is being checked on and that everyone is okay, you know? But there's a bunch of different ways you can do so. Cash App, Venmo, PayPal, Revolut, Chime. I didn't put everything in the description today. I had very little time. I'm going to fix it afterwards. But the link for debit and credit is in the chat right now. We have Amazon wish lists, all that kind of stuff. You can ask us for the wish list. We had to private the big one because, well, you know, internet trolls and all playing games, but it is what it is. We always figure it out. Any and all support is always welcome. Make sure you guys hit that like button. I said the same thing. I mean, I get a little bit of where they might be going with the strategy, but I still think it's going to be, we're in Massachusetts. You know what I mean? Like, I live here. I know how tough it is. I mean, it's easy for criminals in some ways. In some ways, it's a lot harder. And you're talking about a trial, I don't know how they're going to, yes, you could take out some statements, but some the judge is going to let in because they're going to have elements of both. You know? I'm definitely thinking that the only problem that I would have if I was his defense attorney is like, how do you say you moved a body, right? The only way to do that, you pled guilty, so third party culprit, right? Or what? Someone took you hostage, held a gun to your head, made you move the body, or accident. It was an accident. She fell down the stairs and I disposed of her body. You know what I mean? Those aren't usually winning strategies. The whole it was an accident thing. Once in a blue moon, it hits with the jury, you know? But ooh, I thought about making Christmas cookies last night. And I was just so tired from being sick that I was like, no, I need to go to bed. I need to go to bed. I'll send you the link, BJim, just in case you want to pop in and give your thoughts. I don't even know what they're doing right now. It's weird. Yeah, I only need to hear one witness and we're good, right? Conspiracy dog walk, Scorpio? Chocolate chip. Ooh, chocolate chip cookie dough. I liked him as a judge in general. Thought he was pretty good, but I didn't watch the Zach Anderson one, so can't comment on that. Ooh. Ouch. Head injuries are no joke. No joke at all. Oh, man. It's supposed to be, right? But hold on. Let me see something for a second. Let me see. Let's go back for 1 second here. What's the last one? Well, there should be an age limit on judges too, though. If you're to the point where you're more slow going or
Take a look at what I added.
takes you a long time to like make rulings and understand things and think it's time to retire, you know? All right, so basically, yeah, she just tells them to take a look at what she added, I'm guessing, to the plea of the questionnaire, whatever. And then that's it. That's like, I don't understand what the hell is going on here. Oh, yes, girl. Yes, do it. I love baking. I hate cooking. Does that make sense? I hate cooking, but I love baking. New creations of baking. Like, what the hell? They give no warning. They just give us this ridiculous screen that looks like this. Like, what in the actual hell is going on here? All right, let's see what the hell Ted Daniel posted while we're waiting for that. All right, he says, breaking. One day after the McCabe's, Alberts, and Brian Higgins expressed their intent to sue Karen Reed, and Aiden Kearney Reed has filed her own suit. I'm going through it now. We'll post our reporting as soon it's ready. I was supposed to say as soon as it's ready. Karen Reed, plaintiff, versus Michael Proctor in his personal capacity, Gary B. Koenig in his personal capacity, Brian Telly in his personal capacity, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. I have to make a statement here to say this is fucking stupid. I'm just gonna say it out loud. It's fucking like her suing these people. In my opinion, and this is my opinion, at this point is theater. It's theater. It's literally just theater for the public because no judge, they've been not arrested for any crime. They're not suspected of any crime. There's no evidence they committed any crime. And so no judge is going to be like, oh, cool. You use these people as third-party culprits in your criminal case. Therefore, we will now allow you to spend years harassing them some more with, quote, lawsuits just so you can prove to the public that you really were innocent. That's not... Oh, okay. I'm just saying, this is theater to me. There is nothing that you could bring into a court that the judge is going to like, sure, great. This is such a up and up lawsuit. It's not. These people didn't harass her in any way. These people didn't talk to her. These people, you know what I'm saying? So you can't go on a conspiracy theory with no evidence to it and be like, well, now I'm going to sue these people. That's just not, her lawyers a long time ago, yeah, fodder, in my opinion, is exactly what it is. Just more BS to sort of rile up the people to be like, I need help paying for my civil suit that I have for the wrongful death suit. So I need y'all to, keep chipping in, because if you look at this strictly from like a legal standpoint, with everything we know about that case, this is going to fail miserably in a court. That's my opinion. It's just going to fail on its face. There's no teeth to any of that whatsoever. And so let me see if I can see. It doesn't say. He cropped it. He cropped it so it just says defendants and then doesn't. Right, exactly. So I think this was her attorney's idea to probably add these names into like the death suit or whatever, meant like they were saying before, although I don't think the judge will accept that. The judge is going to say, if you want to file those need to be filed as separate cases. You're not just going to drag in a bunch of random people just cause. I could tell by the look on the judge's face last time that he was like, yeah, no. And most judges wouldn't, at least here in Mass. I don't know about other states. I can only speak for where I live here and the stuff that I see. This, in my opinion, just fails. It utterly fails. What would you have to sue them for? You can't sue them for emotional distress. You said they were third-party culprits. They're the ones who suffered the emotional distress from your attorneys. You can't sue them for defamation because you were charged with a crime and their opinion is that you killed John. So what would you be suing them for? Yeah, you know what I mean? It just doesn't make any sense because there's nothing to go with it. It was filed weeks ago. Someone said it's only appearing on the docket now. Shocker, the day after it's announced that, the witnesses are going to be suing Aiden and Karen. I can't. I just, the fact that I'm like reading the comments and some of these people have no idea what they're talking about. And it's kind of sad. They're like, oh, they're going to sew the pants off them. It's like, you guys don't even realize this is just, it's going to fail in a court. It just is. There's no. It is. And that's why I keep saying that our laws need to start catching up to the digital age, right? Because, I mean, judges nowadays hate using, at least here in Massachusetts, sequestering a jury. Sequestration is something they just don't like to do, but it's necessary. There's a reason it's an option. It's necessary for many reasons, social media being one of them, right? You heard the judge in this case yesterday say, well, I want these jurors to agree to stay off social media completely. And it's like, cool, you can ask them all you want and tell them that they have to. But the reality is they're humans and they're probably not going to, right? How would you know if they did is the point. You wouldn't. So they can say they did. As we know, jurors in this case, right, in the Karen Read case, raised their hands and took an oath and still lied. So what stops the jury in this Walshe case from doing the exact same thing? Matt Tim Panic, 1 of 2. Tactical decision. Those charges were low-hanging fruit for the jury, which I figure. I have to think the guilty plea will preclude the prosecution from discussing some of the strongest circumstantial evidence of guilt against the defendant, which is what I'm guessing. But at the same time, they're going to have a hard time arguing that the stuff with the body, right, is not going to be allowed in because it's also part of the murder. So you know what I mean? So that's going to be interesting to see how the judge deals with that scenario and that situation, right? Sequester me, man. That sounds like a vacay to me, Sequester me. They don't like doing it because it is like taking away people's liberties and rights. But at the same time, you can say, I can't be a juror because this would be a, hardship for my family or whatever. And they can find someone else. But there's a reason that sequestration exists, right? There's a reason it exists and it needs to be used. Or our laws need to catch up to the digital age in trying to figure out how you keep a jury from going on social media and reading conspiracy theories on cases. Or how do you know that they weren't doing it before they walked into the jury room? That's another problem, right? If we want fair trials, like the rules of this stuff were made a long time ago, long before social media and all this stuff existed. The problem is they haven't kept up and they haven't evolved. They haven't evolved with the time, right? And so it can't be a fair trial for either side. If you have jurors walking in and lying and accessing social media and doing all of these things, there's got to be better. And it could be better for the defense in one aspect, or it could be better for the prosecution in another case, right? That's not a fair trial. That's giving one side or the other a very unfair advantage at that point. And so we got to figure it out. We got to come up with some new ways that juries work, right? We can't have the old rules of you're sequestered so you don't get a newspaper or a TV. Well, now we have phones. Everything's at your fingertips, right? That's not going to work. But you can't tell people that they can't have a phone because they still have families and lives, right? And so how do you do that? How? The question is, I don't know. The answer is I don't know how you do it, but the question still remains, Do you just do nothing? No, something has to be done. Otherwise, it's going to get more unfair and more unfair and more unfair, right? And it's not a quote fair trial anymore for either side. And that's a huge problem that we already have and we've had for many years. Like I said, there's plenty of innocent people who go to jail as well, and it's almost impossible for them to get the fuck out of there, even with evidence proving, DNA proving that they're innocent, right? Decades later. It could take decades, or they may never get out because they already exhausted their appeals and they exhausted any sort of option, or the very last option they had the evidence, but the judge still said, no, we don't care. The DNA shows that you're innocent, and the judge rules against you. An innocent person should never sit in prison, especially if they have, evidence to prove that they're innocent. Lots of things happen. Eyewitness accounts are very spotty. Very spotty. There's a reason why you want all the evidence you can get without eyewitnesses, because eyewitnesses can be wrong. They can add things. They can subtract things. They can say the person was wearing a blue shirt when in fact they were wearing a red shirt, right? They can misremember things. They can add things in to it. Good morning. I know it was interesting. It caught me off guard. It caught everybody off guard. We were expecting jury selection. We certainly were not expecting him to plead guilty to 2 of the counts of the indictment, although it wasn't the big kahuna. It was still the witness intimidation and the sermon of a body. So I don't know. I'm trying to see right now let me see. Let me see. Darn it. Let's see. By the way, I might as well announce this right now. I mean, there's not a ton of you, but my good friend Kara, her birthday is the day before mine. So last year I was the unfortunate soul whose birthday was on Thanksgiving. It's on Thanksgiving every so many years. This year she's the unfortunate soul whose birthday is on Thanksgiving, and mine's on Black Friday. Mine's the day after. But last year, we all got together and contributed to a gift for her. So if you know Kara, and you would like to contribute to the gift this year that I'm going to put together for her, you can just send me an email or a message and let me know. I want to get it done, before the weekend is over. That way it can be bought, ordered, and sent before her birthday. So last year I got my purse, which is, I told you guys, it's like a side, purse. And I love it. And I've been using it ever since because it's hands-free. It's a very nice purse. And people got together and did that for me last year, which was the first time that a group of people got together and bought me a gift. And it's something I'll never forget because it was such a nice thing for people to do. And when you don't have a ton of family like I don't, nice things like that don't happen often. So it's nice once in a while when something like that does happen. And I want to give that same feeling to the people that I care about, I will just as much pay for it myself, but I also wanted to give people the option. Oh, thank you. Let me see. Oh, yep. I see I have a message. Oh, girl, you're telling me they suck. They suck. Because my youngest, her birthday is this Friday, right? And then my oldest is 3 days, and my birthday is the next Friday. So hers is this Friday, mine's next Friday. And then my oldest is 3 days after that on the 1st of December. And then my middle is the 10th of December. So just 9 days after that. And then there's Christmas. So believe me when I say I want to rip my hair out when it comes to like November and December specifically. I'm like, this is a nightmare, an absolute freaking nightmare. All right, let's see. Okay, Ted Daniel teases you with the parties in the new Karen Reed civil lawsuit. Like if I'll give you the actual document part of it anyway. It's 46 pages long. Oh my effing Lord. Kara's birthday. All right, hold on. my tree, my pink tree. That's my birthday gift. Everything's pink, girl. Look at my pink headphones, my pink microphone, my pink chair, my pink speakers, my pink cup holder. I mean, my thing you put your cup on. My pink pens. Everything is pink. My favorite color. All right, listen. Nobody will ever ruin it for me. Love it. All right, let me get this off the screen, and I'll keep an eye on it over here until they come back. And then I'll put this on the screen. Here we go. I'm so excited to have a Christmas tree now. Last year we had a real one because when we were moving and everything was going into storage, my pink tree broke. It broke. I had it for years. It broke. And Wallflower kindly got me a new one. So, and it's pink. And so I'm going to decorate it all pretty, and I'll show you guys pictures, obviously, after I decorate it, which isn't going to be until after Thanksgiving, but it's going to look so pretty. Yes, with purple lights. She also got me the purple lights to go with it. My pink tree with my purple lights, and I have a black in my storage unit for all the Christmas stuff I have. I have a black skirt, a tree skirt, and it's glittery. It's a glittery black. So I usually do a pink tree in purple, black, white, and silver, ornaments, and then it's going to be beautiful. I use white. I use white, purple, silver, and black ornaments. You are fresh. God damn it, you freshy. All right. Oh, God, this is so small. I can't even make it bigger if I wanted to. I wish it was bigger for you guys to see. All right. So it was filed November 17th, it says. Well, that's when it was stamped, at least. I thought about trying to find black, like, garland, but I haven't seen any. I've seen one, and it was like this big, so it was like probably enough to go halfway around one part of the, like, the bottom or the top or whatever. And I was like, oh, well, that's not big enough. But I thought about that. Oh, those, I have something, like, they're silver, but they're not disco ball, but that would be cool. The silver ones that I have glitter on them. I don't even know if I have any white ones. I have silver and a couple black and a couple purple, but some of them broke. Some of them got squished in the box. So I have to go through and see how, I think I have enough, but I also have some pink ones as well. Some, there's like a candy cane one, and then my kids have their, special Disney ones, and I have a couple of my grandmother's older ornaments. All right, it says, for 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation. They didn't really say public condemnation. Like, is that real life, number one? Number two, how is that the witness's problem is what I want to know. All resulting from the gross misconduct of the Massachusetts State Police and those working in tandem with the MSP. Okay, so here's the thing. To shield from liability the party or parties responsible for the death of Boston. Okay, so they're still going with this whole conspiracy theory. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those. Okay, so here's the thing. She is suing 1, 2, 3, 4 cops in their personal capacity, which, here's the thing. Buchanan, Tully, and Brian Higgins, she's going to have a hard time, specifically with they were cops, right? Yes. They don't know, right? That's the other part that's going to kill them, which is all the inconsistent statements. We know who did it. We don't know who did it. And it's not for us to know, they said, right? That was the most recent one. So that's not going to help them, first of all. Second of all, qualified immunity is the thing, right? And the cops doing their job, you can't just sue a cop because you don't like the way they did their job, right? You can't, that's not the way it works. So, you know, you might not have liked some of the things that Proctor said, and with him, you might have some sort of reprieve, you know, with that, with his phone. But Buchanan, Tully, Higgins, you got nothing. You got literally nothing. They have qualified immunity under, you know, under the doing what they're, you know, doing as a job underneath the umbrella of working for the state police. You can't prove any gross misconduct by Brian Tully or Brian Albert or Brian Higgins, because there wasn't any. None existed, right? Or Yuri. So I don't know. Like this whole thing is already into the whole. She was wrongly accused and then she was acquitted and wham. She did not kill her boyfriend, Mr. O'Keefe. It says, and basically says that law enforcement failed to ensure that justice was sought and served. Which again, you could say that, but for legal proceedings, that's not gonna work. That's not going to work. The judge is going to be like, okay, whether you think they failed in their job or not is irrelevant. You don't get to sue them for it. That's not the way it works. So cops make mistakes all the time. It's not the way it's just not the way it works. There's a high bar to be able to sue an officer in their personal capacity because you don't like what they did in their own work. Plus, they did exactly what, you know, was part of what they were supposed to do. So I don't, you know what I mean? So it's saying basically an altercation during a late night house party happened after a night of heavy drinking. The house defendants responsible for his death, some who had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Okay, this is all just nonsense, right? And I get for some of you who believe she's innocent, you might not agree with me, but hear me out, okay? You can write all of this in a legal document. You can write all you want. They're even going with the Google search still. Among other actions, the House defendants conducted a Google search for information of how long Giant Cold moved Mr. O'Keefe's body outside and placed him on the Albert's front lawn near the road to make it look like he was hit by a vehicle and that he died in the snow without ever coming into the house that night. Except his phone never moved. He didn't go in the house. And, well, the Google search has been debunked like 17 fucking times already. So the fact that they're even putting this in a filing is, to me, reeks of desperation at this point, and just fodder. You know, here's the thing. It says, from the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. No, her taillight and car did that. Her own statements did that. They didn't do that, right? That's easily going to be proved. So again, that making that statement in this means nothing, right? All of that is disproven almost immediately, right? Okay, so from the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. The House defendants were well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. That's just false because the investigating police officers were not Canton PD. They were the state police. The state police didn't know these people. The only one person that had any connection to them at all was Proctor, and that was like his sister went through like his sister's like 3 degrees of separation, right? It's frivolous. And this is my point, which is even if you think Karen Reed is innocent and didn't kill John O'Keefe, to get to this level of conspiracy that these people are putting in this, right? It should, like, a lot of people have admitted that they thought that it was an accident, right? Or they thought that they thought the police investigation was sloppy, so they thought she should have been found not guilty. Not that she didn't do it, but that, you know, the investigation was sloppy, so they didn't think she should be found guilty. And then I've heard, well, the Alberts did it, but nobody can ever, or Higgins did it. Nobody can ever answer the very serious questions, though, which are, John's phone stops moving forever, within seconds of Karen Reed's car backing up. It never moves again until he's found that morning by Karen. So how'd they get him in the house without his phone moving an inch or a quarter of an inch, right? They left his phone outside the whole time. Well, how'd they get his body? How'd they move his body in the house and leave his phone outside the house? And how, just how does that happen while Karen is backing up? That means she would have had to see the entire thing, right? If they threw his phone on the lawn right at the time that she was backing up, she would have seen that going on, right? She would have seen that incident. So there are questions that cannot be answered simply because the answer doesn't exist, right? He didn't go in the house. We know this. And I specifically know this because the FBI did go in the house and the FBI tested inside the house. And do you know what they found inside that house? Nothing. No blood. No, nothing. Not a goddamn thing. If he died inside that house or was bleeding inside that house, I promise you there would be blood left behind. It gets into the cracks. It gets under rugs. It goes into places that you can't just bleach out, right? So they went in there. They found nothing. They had everybody's movements. They had everybody's phone information, the feds did. And do you know what they found? Nothing. They found text messages they didn't like from Trooper Proctor. That's what they found. But that was it. That is all they found. Okay. That's it. So they're basically saying Michael Proctor grew up in Canton and resides there. He has been and remains close personal friends with the Albert family. That was proved to be false. That he wasn't close personal friends with them before this. You can't. You can't. There's nowhere that you can read that. You can see pictures that they took inside, that the defense team took inside. The homeowners who live in the house now, they allowed the FBI to come in and do testing in the home, just like they allowed the defense team to come in and do testing from the home. And so like, people don't realize there's a reason that the federal investigation was closed long ago. It was closed long ago because they found nothing in that home and they had everybody's movements. They had everybody's phone records. They had information that the state didn't have, right? They had all these things that the state didn't have, which is why the state has to make these TUI requests to the federal government for certain things, right? And the federal government doesn't have to give up other things, which they didn't, right? So they gave what they thought was exculpatory, but there's many other things that they didn't get, obviously, and exculpatory information that they didn't think was exculpatory, including, you know, people's phone records that the defense had already been denied, and it didn't matter. They can't just hand that stuff over, you know what I mean, even if it's been denied. So it's like, that's why they had to file TUI requests to get certain things. I think it was 2023, so it wasn't even a year. Yeah, 2023, I believe. So it wasn't even a year. And again, even if it was afterwards, blood doesn't just disappear. You can try and bleach it, but it gets into places that there's no bleaching. So for instance, you're in the garage, right? There's cracks in the garage. It's going to seep into those cracks. You can swab down inside there and you're going to come up with blood like that. You can try all you want to clean it up, but there's a reason why. If you're saying it happened in the basement, it's going to seep into places and boom, you're going to come up with something, a hair, DNA. They found not only nothing, but the movements of the people in the home. They had the geolocations of everyone. John never went in the house. They had all their phone records. They had their geolocations. There's a reason they closed the investigation into that. It was closed for a reason. Oh, that's such a great show. I love Forensic Files. I probably haven't watched that in probably 8 years, but it is a good show. Okay, so basically adhering to the unwritten rule of, quote, protecting their own. They literally wrote this in a legal filing. I can't. Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to O'Keefe's murder. Except there was no compelling or obvious evidence. You have someone on the front lawn screaming, I hit him, I hit him, I hit him. And Karen herself, in her interview, that came out in between trials 1 and 2, because she did it during trial 1, thinking there wasn't going to be a trial 2. She admits that she said, I hit him, I hit him, I hit him. She says she just doesn't know if she said it as many times as law enforcement is saying that she said it. That's her own admission, right? If somebody is outside, out front saying, I hit him, I hit him, I hit him, they now definitely do not have any legal reason to be going into that house. None of the witnesses in there saw him go in. None of them. Okay? None of them. And then you have this lady outside saying, I hit him, I hit him, I hit him. Yeah, it's still on break. Like, what in the actual hell is going on? We're still getting like that beautiful, whatchamacallit, screen. This thing. That beautiful screen that we got here. So that's a problem, right? So they say he had bruises and lacerations on his face and a deep gash to the back of his head, suggesting he was punched and fell backward, hitting his head on a rigid surface. Karen debunked that herself. Just FYI. Okay. He couldn't have been punched. He had no broken bones. And the raccoon eyes are a very well-known medical thing that happens when someone hits their head. He had no broken bones. And Karen herself is the one that said she pulled a piece of glass from his nose. So he had a scratch on his nose, a scratch on his eye. So she pulled a piece of glass from his nose. Stands to reason that that little cut under his eye is probably also from glass, right? We know what the raccoon eyes are from. That's from hitting your head. Just ridiculous. It's not consistent with a physical altercation on only one side of your body. That's just ridiculous to assert that someone would get in a fight and only one side of their body would have any sort of issues. I mean, come on now. I mean, let's just be simple here, you know? Equally. All right, so basically what I'm reading here is the same stuff they asserted in trial 1 in all of this, except the problem is Proctor. I see a lot of Proctor. This just fails on its face, right? That's my opinion. I don't think a judge is going to continue with this lawsuit. I think it'll be short-lived. I mean, the judge has to look at it. That's the bottom line. It's filed, so the judge has to look at it, and there's going to be an answer, obviously, that gets filed, and the judge has to have a hearing and all that. But I have no doubt in my mind that it will be very short-lived. They did go into the house. The federal government did. The federal government went in afterwards. But no, why would the police go in the house? You have a woman on the front lawn screaming, I hit him, I hit him, I hit him. So why would they go in the house? You know what I'm saying? Like, think about that for a second. If you're a cop, you get to the scene, right? And none of the people in the house said that they saw him commit. They did not see him go in. He did not go in the house. But you have this lady outside screaming that she hit him, she hit him, she hit him, right? What legal authority now do you have to go into that house? You don't. The cops did go in the house right away, which was something that was asserted sort of early on that the cops never went in the house. They did literally go in the house right after John was taken in the ambulance. 2 officers went in the house and were in the house talking to Jen, Brian, and Nicole. They were physically standing in the house. They were in the house. They didn't search the house because there's nothing to search. They were literally standing in it. Clancy's change of venue? What? Why is she asking for a change of venue? Hold on. Maybe that's why they stopped the Walsh thing. No, because it's different. It's a different district. I mean, different county. Hold on. Kevin Reddington is her attorney. You say Court TV? I don't see it. They're back? No, wait. Huh? What do you mean? I have it on right now. Oh, not back yet. Oh, Lindsay, no. What happened when we cleaned Lindsay 1 month ago? And request for delay. I don't see it on Court TV. The Brian stuff's not back on yet. I'm looking at it right now. Unless they put it on a different stream. Well, let me go back and look. Hold on. Yeah, that's where I just was. That's what I had was Boston 10.
This courtroom
Oh, I
and the
see.
law as I teach it to you. If you can do that, then you can be a fair and impartial juror. Now, let me give you a brief description of this case. As I mentioned, this is the trial of a criminal case. The Commonwealth alleges that on December 30th, 2022, Anna Walshe returned home to Cohasset from her job in Washington, D.C., to be with her husband, the defendant, Brian Walshe, and their children to celebrate the new year. At that time, Anna Walshe lived and worked in Washington, D.C., and would return to the family home in Cohasset, where her husband and 3 small children continued to reside. The Commonwealth alleges on January 4th, 2023, Anna's employer called police to report that she was missing. Cohasset police went to the Walshe home where the defendant reported that Anna was missing and alleged that she had left the house early the morning on January 1st and that he had not heard from her since then. Days later, police searched a dumpster outside the defendant's mother's Swampscott apartment and found clothing that belonged to Anna Walshe, Anna Walsh's COVID vaccination card, towels with red-brown stains, a hatchet, and a hacksaw. The defendant is charged with murdering Anna Walshe. The defendant denies these allegations, is presumed innocent, and has pleaded not guilty. I will now ask the lawyers to introduce themselves and to tell you who they represent. We'll start first with the Commonwealth. ADA Connor.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Greg Connor. I'm an Assistant District Attorney for the Norfolk District Attorney's Office, and I will be representing the Commonwealth, along with...
Good morning, ladies and gentlemen. My name is Tracy Cusick. I'm also an Assistant District Attorney at the Norfolk County District Attorney's Office.
And I'm also an Assistant District Attorney, and my name is Ann Yaz, and I will also be representing the Commonwealth.
And for the defendant, Mr. Walshe, Attorney Tipton.
My name is Larry Tipton. I represent Mr. Walsh.
Good morning, ladies and gentlemen. My name is Kelly Porges, and I'm also here on behalf of Mr. Walsh.
Good morning.
Thank you. Let me talk
Yes,
a
this
little
is
bit
live.
about the trial for the schedule.
Judge,
Schedule
I
for
love the
trial,
judge's
sorry,
hair.
that way.
I love it. I love her
Today,
hair.
as you know, is Tuesday, November the 18th.
She's got the Rachel haircut, I feel like,
We
right?
plan to select the jury before Thanksgiving, and we will start the trial itself on Monday, December the 1st, 2025. The lawyers estimate that it will take between 3 to 4 weeks to try this case and to present all the evidence. The jury will then meet to discuss and consider the evidence and issues.
Right,
in the
doesn't
case,
it?
And we call that deliberation.
I said yesterday I
To
loved her
reach
hair.
a decision, which we call a verdict. There is no set time for a jury to decide a case. The jury takes as much time as it needs to unanimously decide the case.
I knew it would be a long one.
During the trial, while the evidence is being presented, our typical daily schedule will be between the hours of 9 a.m. and 4 p.m. We take a morning break at 11 a.m. and a lunch break between the hours of 1 and 2 p.m. There may be a day here or there, typically on a Friday, that we might suspend early depending on the pace of the case.
Oh, for fuck's sake, this early until 4 o'clock bullshit drives me
When the
nuts here in
jury begins
Massachusetts.
its deliberations, the jury will deliberate from the
Same.
period of 9
Why I use
a.m. to
contacts,
4,
mostly.
4:30 p.m. And again, we set no pace for the deliberations. The jury takes the time it needs to decide its case. Before we begin selecting jurors, I want to briefly explain some important legal rules that the jury
Makes no
must
sense to me.
follow. And at the end of the trial, I'll give you more detailed
She's saying
instructions
early
on the legal
sometimes
rules that apply.
on Fridays,
in
but
this
not
case.
off. But the
me
court doesn't
start
have Fridays off.
By
Court
teaching you about
runs
the
on Fridays.
presumption of innocence and proof beyond a reasonable doubt.
we should.
Every person who is accused of a crime is presumed to be innocent of
Won't be
that
Fridays
crime.
off.
Mr. Walsh
Unless
is
it's a holiday.
presumed innocent of the charge in this case. That means
They'll probably
the
have
jury must
Thanksgiving
consider
Thursday
Mr.
and
Walsh
Friday.
to be innocent at the beginning of the trial and must still consider him to be innocent at the end of the trial unless the prosecution proves beyond a reasonable doubt through evidence presented during the trial that Mr. Walsh committed the crime charged. The fact that the Commonwealth has charged Mr. Walsh with this crime through an indictment and that he is now standing trial is not evidence. And it's not relevant to whether the defendant is guilty or he is not. An indictment is not evidence whatsoever.
Me too, Sam.
That the
Me
defendant
too.
is guilty of any crime. An indictment is merely a formal accusation that the defendant may have committed a crime in order that he or she may be brought to court for a trial before a judge and a jury. It is that jury that is to be selected from among your number, and that jury alone, which must decide whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the offense that has been alleged. Again, based on the evidence and the law that is presented during the trial of this case. The defendant does not need to do anything to convince you that he is innocent. He doesn't have to explain anything to the jury. He doesn't have to testify, call or question any witnesses, or provide any evidence at all, because you must presume he is innocent. Instead, the Commonwealth has to prove the charge against Mr. Walsh beyond a reasonable doubt. If you serve on this jury at the end of the trial, you may not find the defendant guilty of the crime charged unless the prosecution convinces you beyond a reasonable doubt that Mr. Walsh committed that crime. If you are left with a reasonable doubt of Mr. Walsh's guilt on the charge, then your verdict must be not guilty on the charge. Now let me turn to
They are boring.
important rules that you must follow during our jury selection process, and in fact, until your jury service is over. It's important that you keep an open mind about this case. Do not discuss this case or the questions we ask during our jury selection
anyone.
process with any other potential juror or
person.
with anyone else. Do not send any electronic communications or posts. In fact, you should be well informed by now that your phones should be off. And if they're not, make sure they are. Do not look up anything
She's not playing.
on
Yeah,
any
they will,
device
and they
to
do.
include your phone. Don't do any research about jury selection or about the case or the people involved in the case. If you are chosen to serve on the jury, you may tell people that you are serving on a jury here in Norfolk Superior Court, and you may give them the trial schedule and how long your jury service is likely to last. But you must not tell them anything else about the case until the trial is over and the jury has reached its verdict. Let me next talk about the jury selection process. When the lawyers and I ask you questions, and many of them are going to come in a written questionnaire, but then you'll come back into the courtroom and have individual questions asked of you. We're not trying to pry or make you feel uncomfortable. Instead, we ask you these questions to determine whether you're able to serve as that fair and impartial juror, whether you have a reason to favor one side or the other, and whether you're confident that you can decide this case based only on the evidence that will be presented during the trial and the legal instructions I teach to you. It's very important that those of you who are chosen to serve on this jury be able to commit yourselves to deciding this case, again, based only on the evidence you hear or see in this courtroom, and not on anything else, such as your personal experiences or the experiences of someone that's close to you that you might know about. It's also very important that those of you who serve on this jury not allow the nature of the allegations in this case to make you lose sight of the question that the jury must decide, which is whether the Commonwealth has or has not proved beyond a reasonable doubt that the defendant committed the crime charged in this case. I will instruct you that the jury must decide this case based only on their evaluation of the evidence presented at trial, and that they may not base their verdict on anything that wasn't admitted into evidence, and also may not decide this case based on sympathy, prejudice, anger, or any other emotion. All jurors must be able to commit to following these instructions so that they can be fair and impartial and decide this case based only on the evidence we hear and see in the trial. If we do not choose you to serve on the jury, please don't be offended. Sometimes a person who could be a fair juror in one case might have difficulty being fair in another. For example, a potential juror who knows someone involved in a case or has a personal experience that is very similar to the issue raised in a case might have difficulty being completely fair to both sides. So please keep these thoughts in mind as you answer both the written and the oral questions. So jurors, I remind you that there are no right or wrong answers to any of the questions on the questionnaires. And in a moment, the court officers are going to hand out those questionnaires, and I will give you an opportunity, some time to fill out those questionnaires. When you finished filling out the questionnaire, fold it in half and put it somewhere safe. Don't show it to anyone else. Don't share the questions or your thoughts about anything in the questionnaire with anyone else. Doing this questionnaire and answering our questions is a solitary experience. You and you alone. When you safeguard the questionnaire, at some point during the day, you're going to be brought back up to, you're going to be moved to a different courtroom, and you're going to be brought back in smaller groups to go through the individual questioning. Don't show anyone that questionnaire until you hand it to me when you come to the side of the bench and are seated in the witness box, and then I'll take the questionnaire from you. As you also learned during the video this morning, the lawyers play an important role in all aspects of the trial. And with regard to jury selection, the parties have the ability to exercise what we call peremptory challenges. That means that the parties can strike a certain number of jurors in a case. Don't be offended if you're not seated as a juror in the case. We appreciate your sacrifices that you made to be here today. Once we finish our questions, I'll let you know whether you've been seated on the jury or not, and that's the process for today. Fate plays a role in your day today, and by that I mean questionnaires, or the numbers on the questionnaires that I have, start with number 120 and go to number 241. We see people in order of their number. So if your number is closer to 120, you're going to be seen earlier in the day. If it's closer to that 241, later. Whatever your number is, I appreciate, and the parties appreciate, your patience. So at this time, where are the questionnaires? The court officers are going to pass out the questionnaires. If you need a writing implement, let the court officers know. I'm going to give you an opportunity to fill out those questionnaires now. Jim, do you have a, I left this, I left this uncovered, so I have no, and then I will need the list for you.
No, it's an internal joke to myself.
It's all dried up. I left it out, unfortunately.
Okay.
Oh, thank you. That's fine.
I saw that. Not the first time, huh?
I know I'm on mute. I'm on the phone with my sister. Sorry, guys. My nephew has an IEP meeting tomorrow, and I was my sister called to ask a question about it. As a volunteer advocate, I've done many kids' IEP meetings, including my own, my nephew, my other nephew, and then other parents' kids who've had disabilities. And my nephew is on the spectrum and has like processing speed delays, which means basically like what he's thinking here isn't coming out of his mouth, and he's in kindergarten. And so his mindset is more of like a 3-year-old than a 5-year-old. And the school had a concern about something he said about the house burning down and blah, 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 blah. And it was a game, I think, that he had played, and like a video game with like a thing that was on fire. You got to put it out, whatever. And so the school literally called home and was like, your kid's saying that the house burned down and someone died. And my sister's like,
Just take the amount of time
what?
that you need to thoroughly fill out the questionnaire.
Like,
But
I
when
think-
you are done, as I said,
Yeah,
safeguard
see?
the questionnaire somewhere and
It's
just
like,
look
no,
up so I can sort
he's
of get a visual.
trying to tell you about a video game he
check as to
played.
how many people might
And
need a
then
little bit more
instead
time.
of calling her and asking, they literally brought him to the like school counselor and sat a 5-year-old in a school counselor's office and like questioned him. Like, if there was a fire and someone died, don't you think he wouldn't be at school or someone would know? Like, we also think he has ADHD as well. Like, he can't concentrate. He's just like, do, 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 do. I mean, it was ridiculous. And then they said something like, oh, well, it's a safety concern. What would be the safety concern? Even if, and I've had a fire, so this was before he was born, but I've had a fire. Even if my house did burn down and someone passed away, right? Why would that be the school's business? Unless I'm asking help from them, why would that be their business anyway? So what safety concern would that be exactly? You know what I mean? You don't put a 5-year-old who is on the spectrum, which they're very aware of. I got him the IEP when he was in preschool because he didn't talk for 2 years. He stopped talking around 1. I got him to start talking around 3. And so he's very behind in his speech. He's got processing speed delays, and you know how it works with autism. All sorts of different, things are going on. It's like you're using a kid's disability in a weird, that is weird. He's 5. He's 5. He's not 2, 3. He's not 12. He's 5. All right, in kindergarten. And you guys decided to put him in an office and question him about a fire that never happened. I mean, that's fucking weird. Why not just call the parent and ask what you think he's possibly talking about? And you can tell he's behind because like he still sort of can't always understand what he's saying, That's the other thing. They're only supposed to test every 2 years. A lot of times the schools will ask for testing to happen every year instead of every 2 years because they want to like not do something on the IEP. And so when they bring that up, I always say, no, we're not retesting until the 2 years is up, and then we can retest again. Or you can have a test actually done at your local children's hospital or whatever. I can't find the Clancy thing. You might be able to find it on cable, but it's not showing up on their streaming. So I can't play cable. That's the problem. Like, I can't play what they're playing like via cable. I can only play what they have available on their streaming, which is the Matthew Lance Stranger Home Invasion Murder Trial at the moment. That's the only thing that I see that they have that's live right now. Yeah, it is weird. Usually they have more than one, so I don't know why. But I can't stream like cable. I don't have cable anyway, but I couldn't stream cable from like the TV to here. You know what I mean? Let me just try one thing. Hold on. Yeah, she's in Mass too. Let me see. Let's see if I can check. Okay, hold on. Be able to see it on their website. Hold on. Yeah, I'm looking. What the hell? Load. What is happening? Oh. All right, hold on. Here we go. I found it this way. Oh,
Ms. Clancy through her attorney, Mr. Reddington. I did review the report of the psychologist that was provided. You know, what strikes me about it.
hold on. I just want to pause this. Actually, you know what? I'll just let that play because then I'll hear when they start up again.
It doesn't seem as a request for an accommodation. It seems as a request for a change in custody status. I don't know how someone can be in custody and it act as like a buffet, if you will. I want you to pay for my medical care. I want you to provide me protection. I want you to pay for my transportation, but I don't want to be searched. I don't want the handcuffs. And that's obviously very troubling from a correctional standpoint, because obviously if Ms. Clancy is remanded to our care, which she is at this point because she's held without bail, we have received a HABE from the court to transport her. She becomes our responsibility, our liability. She's in our care and custody. And our officers are very good at what they do, and they weigh a lot of security factors. And the courts, even in conducting an ADA analysis, give a lot of deference to jails and houses of corrections and the security measures that they employ. I understand the doctor opines that she is not a flight risk and she's not a risk of harm to others. And even taking all of that at face value, assuming that that's true, it really fails to address two major components that the Sheriff's Department is concerned about. And one would be a fear of harm to herself. There is a history here that obviously would trigger certain precautions from a security standpoint to make sure that Ms. Clancy did not try to harm herself. And one I think that often goes overlooked would be the concern about harm from others. This case has received worldwide attention, and while certainly there are many sympathizers with Ms. Clancy, there are certainly other people that very outwardly vilify her for the charges that she has been indicted on. And so there is always a concern with a high-profile inmate that someone may act out on those.
Yeah, she's a prisoner. She should be transported as such.
But obviously could certainly act out on those impulses. And that's one of the other.
No one else gets that benefit. Not even from Bridgewater. You still get shackled.
I know there's been some talk about letting
mental
her
health or
walk in
not,
or come in the courthouse from the front as opposed to the Sally Port. What the Sally Port allows is for her to have less public access. It's certainly not a punishment, but it's a safety concern, and especially in a high-profile case like this, having the availability of a courthouse with a Sally Port certainly makes that transfer easy on our deputies. I'm sure it makes it easier on your staff, security staff here as well, because it prevents a member of the public from having access to Ms. Clancy. This would also ensure that she does have armed corrections officers escorting her there in a secure van, as opposed to just arriving on her own. Now, again, the only way I think really she could arrive on her own is if the court changes her custody status.
It was what you would call baby blues, just sadness, just a little depression, and that was with my first. I never had it again after that, but it still sucked.
From Tewksbury, we had planned to transport her with a nurse to corrections officers in a wheelchair accessible van so that she would be safe and secure.
All right, I just had one question in regards to the nurse that would be able to go in the seat. Would that have to be a Department of Corrections nurse, or could that be an individual designated, as a private nurse, or how would that go?
So our plan was to have a nurse from the Plymouth County House of Correction, one of our staff medical officers, go. I don't think, in our experience.
Yeah.
All right, Lindsay Clancy, who is confined to a
What the
wheelchair
hell?
after the incident. She
Like,
jumped
hey,
out of a
guy, we
window,
want to hear the
trying to
rest,
take her own
dick.
life after taking the lives of all three of her children. And now they're trying to work out the logistics as part of this pretrial hearing, setting up Summer's scheduled trial. Let's bring in Claudia King. She is a domestic violence
hey, buddy,
expert
how
and
about we
former
hear the
law
rest of it,
enforcement
dick?
officer. This is such a heartbreaker.
So annoying.
And there's been little mention of it here in this
Yeah,
hearing
I
about
had the baby
how
blues.
some people in the public sphere have supported
Mine wasn't
her,
as bad as
but
other
then there
people's,
are
for
others
sure.
who vilify her and who are, and the concern is now that she may be the target of some wacko trying to inflict violence at trial. Talk about this case overall. It's just,
Oh, for fuck's
it's hard to
sake.
get your head around. How does this happen? For, human beings, she's a nurse. She's a mother of 3. And now she's on trial for triple murder of her own
They
kids.
had her on like 16 medications or something, 12 medications,
I know,
something like
Ted,
that.
it
A lot.
is absolutely heartbreaking, and I think it shines a light on a few different things. One of them is postpartum depression, and that is a really real thing.
Yeah, it does take a
I
long
think
time
the
for your
other
body to heal. And
issue, though,
postpartum is a real
how
thing.
to properly handle that and how to ask for help, because it does look like she was getting treatment from a couple different physicians, but it also looks like she sort of planned out this timing of getting her
That's the other
husband
thing.
out of the house so that she could commit this crime.
There was sort of
And
both
if
things
that's
happening.
true, that means she had the opportunity to say to him, hey, I'm
Yeah, she
having
was
these
on
horrible thoughts.
a lot of
Something
different
is
ones.
wrong.
That's
Please
another
help
problem.
me. So I think it's going to shine a light on some of these
Yeah, no,
mental
mine.
health
That's why I say mine's
issues
not even
that we
close.
don't often talk about.
Yeah.
Yeah,
It's
all
gonna
those
be
meds.
a
She was on
difficult
like 12
trial
meds, which
for
could have
the
interacted with
jury
each other. A
and,
whole.
for the audience.
This case is
people
a
who watch
mess
it
because of all that.
Of the just heavy-hearted, Cora, 5 years old, Dawson, 3, and
But the
Kaylin,
setup is the
8
other
months,
part that gets me too.
all
Is she
dead
had
at
to.
the hands of her mother, or their mother, and now she's
had
on
to
trial. Let's go
plan
right
for
when we
him to
come back.
leave
We'll
the
head
house,
back,
which was
pick up the rest of this pretrial hearing as
heartbreaking.
the
Yeah, both
attorneys
things can be
discuss
true.
with
It's
the
just
judge
hard
the
to
logistics
grasp,
for the upcoming
you know,
trial of Lindsay
with children
Clancy out of the state of
involved.
Massachusetts.
It's a hard thing. Most people can't even watch trials that have anything to do with children for
How
good
prepared
reason.
is your family?
You know,
If disaster shows up at your
it's
doorstep,
heartbreaking.
you can't just turn away
Let
a natural
me mute that and then pop back over here. I
You're gonna
stopped
be
it just a
seated
second ago.
downstairs in another courtroom for a bit of time. So at this point, court officers are going to move everyone but the first group, right? Down to the first floor to courtroom number 10. Again, I'm going to remind you of a couple things. First, you cannot talk to anyone by any mechanism. No texting, no phone calls, no emails, no nothing. Tweets, nothing. Keep your phones off during the time of jury selection. Second, don't speak to each other about anything while you're down there. Again, task of being selected or being chosen as a juror is a solitary task until you come. So I appreciate your patience, and we'll see you all, depending on your number, in a little bit or later in the day. In a little bit or later in the day. Thank you very much, Bruce.
Why is it bubbling like that? And what the hell is this on the screen? What is happening right now? Hey, you guys, the school's captioning is going a little wonky there. Wonky dokes. So that's that for now. Hello, and it could be why they had Kelsey in jail. They're trying to prevent.
I have a slightly different viewpoint than you do during the time that the jury was working, and I want to share with you.
It is a full moon for the interwebs.
Questionnaires.
You are right, Christy.
There were a few jurors, and notably 2 gentlemen in the front row who, to my eye, appear to be struggling to do the questionnaires independently, or sort of collaborate with each other. I don't know if they came together, perhaps they knew each other beforehand. But when I've asked the court officers to take note of those jurors, I think I will remember who they are. And when that happens, I will alert you to the fact that they're coming, as I'm concerned about their collaboration when it was my clear expressed direction not to. So I just wanted to alert you. All right.
Wonky is right, my friend. I'm done with the wonky. I've
left a few other matters. Just
had a wonky 2 weeks and I'm tired from it. I'm telling you. And this medication is wiping me out. Tired. Don't feel good.
You have one? Is that the final version? Okay, great. And that has the two-page witness list on it?
It does.
All right. And then as Exhibit B for identification, the trial order, have I shared this with you yet?
I'm sorry, Your Honor, I don't believe so.
I think I have extras. This is my standard trial order, except I changed it in this case. So if you've tried a
Court
case
TV is
before,
still on a.
it's the prohibitions against don't speak to anyone about the case. Don't do
We'll
any
be right
research
back,
about the case and have open
Marshall.
minds. How I changed it in this case, in light of the attention this case has had, is I am directing them to avoid any social media or news media accounts during the trial.
No, it's a
Specific
different
to this
county.
case At all, because I don't want.
Plymouth County.
On it at all, and that's something that I'm.
This
going
is
to
the Brian
discuss
Walsh
with
case
them
right now.
In the individual questioning.
We bounced back and forth.
They've got to buy into that, and that's a big ask, as I mentioned to you earlier. But it's necessary.
That's okay.
In this case, to keep them in that.
We were bouncing back and forth between Clancy
state of being.
Yes, Your Honor.
and this one.
Anyone want to look at this? I think I have enough to give you extras, and we're probably not going to.
I can make
copies
copies.
anyway.
I can make copies.
That's all right. I think I have enough, so I gave one for each of you.
Crap. Hold on. They're going back to the court. I'll pause this one, but they're going back to the court on the Clancy thing.
You know, sort of to make it run smoothly. And obviously, since the van will be coming from Plymouth House of Correction anyway, it would be easy to put an extra employee on that van. As far as it being a private nurse, I'd have to talk. I do have our AD, our assistant deputy
Maybe like
superintendent of
February,
transportation here as
I
well.
believe.
I would like to further explore what the security concerns may be for that. I'm sure it's doable. It may just also involve a path risk of that particular individual, but probably doable.
I'm not asking for a commitment. It's just,
No, I
because
understand.
this is really kind of just to get information. At some point, I'm going to have to issue a specific order. So this is very helpful.
Yes.
Um,
So it's probably, again, I'd want to speak with him, but what our plan had been was to send one of our medical officers from the House of Correction just to get on the van before it went to Tewksbury to pick her up.
all right. Either counsel, any questions? Mr. Reddington?
Second question here.
Any further questions?
No, I don't have the questions.
Attorney Sprague?
No, Your Honor.
All right. Attorney Kay, thank you very much.
Thank you.
All right. My thought would be to hear from both of you at this point, and then I'm going to have to kind of fashion an order in regards to that. So I'm not going to rule right from here in regards to how we're going to do this, but this has been very helpful, and then get some feedback from counsel. So Attorney Reddington, I'll hear you in regards to what your suggestions are. And again, keeping in mind, this is going to be months from now. And so the hope would be to kind of put something somewhat in place so that we can talk about it, and it can kind of, if things don't seem like they're going to work or someone has a better idea, we can do with it. But I think it's something we need to address sooner rather than later. I don't know, Attorney Reddington?
Thank you. Yeah, I do have a better idea, and I think, Your Honor, that this is a power play. You have here the attorney for the, congratulations on the appointment, chief counsel to the Plymouth County Sheriff's Office. Apparently, there's also another person that's here, I forget who she said, the assistant deputy of security. We have medical officers. We have a lot of the administrative staff from the Plymouth County Sheriff's Department is here. It's not about the Plymouth County Sheriff's Department. Nope. It's not about, well, she belongs to us. It's not about, well, we're going to have her transported in a van that we don't even know what it looks like. We don't even know what type of medical equipment or
Reddington's a good attorney.
in the van.
Well known.
We don't know whether, I mean, this is like at the time of the original arraignment, where they wanted her to be held in the Department of Correction or South Bay, and that if there's a medical issue, she can go to Lemuel Shattuck. And I refer to Lemuel Shattuck as the great hole of Lemuel Shattuck, because anybody that knows anything about the criminal justice system in this state knows
Shattuck's gross.
that Lemuel Shattuck is not a place that you want to go for medical care. And unfortunately,
Nope.
too many people have to go to Lemuel Shattuck in custody for that. She's not in custody other than your order, which is understandable, to hold her without bail. She has not been convicted. She is still presumed innocent. She is still a citizen of this country.
He isn't saying
She
anything.
is therefore an American. She has a clear and present, despite what others may think, disability that is debilitating. It is daily. It is 24/7. She lives with that as a paraplegic. Your Honor can well imagine the medical issues that are involved. She needs help with day-to-day personal issues. She needs help, regardless of the sheriffs thinking, no, we can throw some guy from the medical department, like a veterinarian, and throw him in the back of a van and make sure that the van doesn't have cockroaches running around in it. We can chain it to the floor, and then we can bring her into the courthouse. We can run her through the Sally port, and
Well,
we can keep her in the
that's
jump
what happened
cell.
to anyone else.
My suggestion to the court, when I filed the
Just
motion
saying.
requesting that there be an accommodation under the Americans with Disabilities Act, I don't care if I filed it with the wrong place. As far as I'm concerned, this is the right place, right here
The court,
before
yeah.
you.
Yep, that's right.
As an American with a disability, she is entitled to the protection of the federal law, regardless of the Plymouth County Sheriff's Office position.
Correct. That's correct.
She's entitled to have a least restrictive alternative
Correct.
to her custodial status prior to and during this trial. I've worked with these gentlemen for many, many years, and they're very, very capable, very, very competent, very, very compassionate in dealing with people and citizens that are in custody, presumed innocent. I have absolutely no problem whatsoever with their taking care, custody, and control of her while she's in the courthouse.
It's not
My
just you. It's
suggestion
frustrating
is
for
that
all of us,
she
I
be
feel like.
brought- is in the
this one.
motion that I brought, looking for some help and looking for some
Two different
least
emotions.
restrictive.
All right,
He
we'll get a
does.
break. Claudia
Oh,
King,
what the
what's
hell?
the issue from a law enforcement standpoint?
Stop
here
it.
with
Stop doing
safety
that.
for
God
and
damn it.
against this defendant in transportation?
Yeah, I mean, there's definitely a big safety risk if you're talking about passing her
can't
off
run.
to somebody else, because now there's an opportunity to obtain weapons, to get away, to slip
Get
her
away in her
something that
wheelchair.
she shouldn't have in the courtroom, or on the flip side, for the wackos that you mentioned earlier to have access to her to try and harm her. So it's a big safety risk. Whereas with
Thanks.
the sheriff's department transporting her,
Not on
they have
camera
all
at the
that in
moment, but
mind. They have a system.
thanks.
They know what to do, and they do it every day.
Okay, interesting argument. We'll get a break, see what the judge says and what the prosecutor says right after this.
Appreciate you. I mean, these breaks are driving me
My goal is to
fucking
make sure that you
bonkers.
remember.
All right, back we go. Back we go to this.
Have any concerns about it? And that will be marked as B for identification. Identification is so marked.
Take this opportunity to remind you guys, if you'd like to support the channel, there's one of a bunch of different ways to do so. Get your memberships to the channel. You can gift memberships to other people. You can do a super chat or a super sticker or Venmo, Cash App, PayPal, Revolut, Chime. We have a link
You're all set with that. I just need it back.
in the chat pinned to the top where you can.
Yeah, that'd be great. Thank you.
Where you can click on for credit or debit. Any and all support. It's very helpful. We're a small channel, so our support only comes from all of you.
All right, everybody else set to go? Bring in juror number 120.
Your Honor, if I may ask one housekeeping question. This is a more unique process to me. I've usually moved on the record for trial, and I haven't done that yet.
You've so moved for trial now.
Thank you, Your Honor.
I see a procedural problem with that.
Just want to make sure I had done it.
Okay. Is that why you were giving me the look earlier?
No,
The
I
look.
just have that face.
I just have that face.
You were looking up to me pleadingly at some point, I thought, but I may have read that wrong. All right.
Probably just thinking of
But
lunch.
good that you asked me a question. Because
Probably
I wanna
thinking
make
of
sure
lunch.
Everybody is,
I love that.
the electronics are working. I actually, Can you go in my top left drawer of in my chambers? And I have a set of headphones, I believe, there.
Hmm. Hmm. Okay, cool. Gotta love when they do that.
Learn more
I don't know
at
why they keep doing that. It's
TabloTV.com.
really
The
annoying.
MVP of TV.
Oh my God, I can't stand commercials. All right.
They were
Arias,
killed by their own children.
That
Menendez.
challenge the legal system and ourselves. Court
Oh
TV,
boy.
legendary trials.
You got us banned from being.
Oh, for the love of God. Hey, Carol. I know, I can't stand the ads. See, I have YouTube Premium, so we don't do ads with YouTube, but this is Court TV, and it is not on YouTube. It is their website because they weren't playing the Clancy stuff on their streaming for some reason. I don't know why, but they weren't. So this was our only way to option to watch it. And I'm cutting out in the middle of the argument. Like, dude, I want to hear the argument, right? I want to hear what Mr. Reddington has to say. I don't want a commercial break in the middle of his damn argument. That is so frustrating. I hate commercials. There's a reason why everybody cut cable and decided they wanted streaming services without ads to begin with. And now all the streaming services are bringing ads back, ones that you can't skip. And I'm like, stop. No one wants commercials or ads. All right. We don't want them. They suck. Go away. I think we're back, but I'm not sure. Yep.
Welcome back. Our focus this hour is in Massachusetts and today's motion hearing in the case against Lindsay Clancy. She's accused of killing her 3 children, Cora, Dawson, and Callan. Clancy's husband, Patrick, came home on the night of the incident to find his wife had jumped out of a window, at which point he called 911. Then he found his 3 kids dead. Let's go back into the courtroom now, pick up this hearing where we left off.
Good. Where we left off.
Terms and conditions of what we're going to do logistically. And I know that this is a difficult issue for the court. I know that you're a compassionate person. I know you've got great experience in your career, and I know that you're concerned.
That's exactly why I won't take SSRI meds, because they give the reverse effect to me, so I cannot take them.
That if the sheriffs have to be involved,
I'm not a fan of SSRIs.
Then, which I don't think they do, honestly, because, and I think for the courts, you're probably more than aware, under Chapter 123, Section 21, it's a statute that talks about transporting somebody who's under a commitment. Transporting, and she is definitely under a commitment per Chapter 123. Your Honor knows that she's under a commitment that was entered back in May. It's good for a year. And the authority for the transportation, I hate to break this to the Sheriff's Department. The authority is not in the Sheriff's Department where they are the almighty end and determine what's going to happen to Lindsay Clancy as far as being in a van and being transported and being chained and being held in custody and all the rest of it. It's up to the head of the Department of Mental Health or
DOC, though. The DOC
she can be transported from
likes to try to take precedence
with
over the Department of Mental
people
Health
that she knows or that she deals with, placed in an ambulance that has the appropriate medical care and treatment, brought to the courthouse, run her through the Sally Port. I don't care. I'm not saying I want to have her brought in the front door, have her brought in the Sally Port, turned over to the care, custody, and control of the court officers, and then placed somewhere in this building, as Your Honor had pointed out, that would be safe and comfortable during the course of this trial.
It doesn't have to be comfortable.
Under
Just safe.
123, Section 21,
Nobody who's locked up is comfortable.
Of the sheriffs is Chapter 37, Section 11. 37, Section 11 is superseded by the mental health statute. It prohibits the use of correctional or police vehicles without written approval of the Commissioner of Mental Health or the facility superintendent. Now, I understand that they have, I guess they call them chase cars.
Doesn't have to
So
be
if they
comfortable.
want to have, you know, a piece of the action, as it were,
I'm
they
also
can throw
shocked.
a couple of guards in a van as a chase car and follow the ambulance to the
Correct.
courthouse. If the government is concerned, not the government,
Then do that.
if the sheriff's department is concerned
Then do that.
about her being attacked and assaulted by people, then let them have a chase car. In other words, they
Correct.
can send a van
To follow
go up
the
to
ambulance.
hospital, put her in the ambulance with a nurse, bring her down to the courthouse, and have their chase vehicle with 2 or 3, however many they need, armed guards to guard the woman in the wheelchair to make sure that she doesn't attack anyone or that nobody attacks her. So the bottom line is that
Makes
the
very valid
least
points.
restrictive terms and conditions of transport and custody during this trial, Judge, I suggest would be to allow an ambulance, a real ambulance, not a medical van with jump seats, but a real ambulance, transport her to this courthouse with a nurse, placed in the custody of the court officers, brought to a room or wherever contiguous with this courtroom so we can try the case. Sheriff's Department has been superseded by the statute. They do not, I would argue, have the custodial authority to transport her according
I'm not
to what they see fit.
A fan of
So I would ask that
SSRIs.
the court would, and you know, I understand you don't have to enter an order today. This is something that can be explored, something that can be considered. My concern is I have a person who's presumed innocent, who is a paraplegic, who, as you heard from counsel's representation, is by reputation and observation docile, quiet, timid. She's not assaultive. She's not a danger. And quite frankly, I disagree. I don't think that the public would want to hurt her in any sense. So it strikes me that under the statute 12321, I think the court has the authority to
That
allow
too. Well, the
Tewksbury
jury
to
wouldn't
bring her
know.
here, have her in the van.
This
have
is
her with a
Lindsay
nurse,
Clancy, Ash.
Let them chase car behind her if they want. Bring her here and then put her in a contiguous room, and then Jen and I can try the case.
To be clear, Your Honor, if you are ordering Tewksbury to transport her, the Sheriff's Department is not involved at all. The only reason I'm here is because the court sent a HABE ordering us to transport her from Tewksbury here. And so we're not, sort of resent the implication that we're interjecting ourselves into this impermissibly. I was
Right.
requested to be here, but
Right,
also.
but you know what? Here's the thing. I'm looking for information. I'm not looking for a fight at this point. There's plenty of time later for this fight. But so I appreciate the sheriff's position.
I can't talk
appreciate
over
the
them.
defense position. I think I've got the sheriff's
Maybe someone in chat can.
suggestion as to how to go for it. I'm hearing the defendants. I'm going to take them both into consideration, and now I'm going to hear from the Commonwealth.
Just to be clear, though, if you do order DMH to transport her, the Sheriff's Department does not need to be involved at
Okay.
all. I mean, that's the only reason we're here is because of the order to transport her from this court.
Yeah.
We're not looking to involve ourselves in some other department's transportation.
And just so it's clear, the court had asked the sheriff's department to be part of this today, so I could get the input into what the sheriff's alternatives would be. So I'm the one who kind of pulled them into this. Attorney Sprague.
Thank you,
Why
Your
though, Your Honor?
The defendant's not only held under a commitment under 123. She's held without bail on 3 counts of murder as well as other charges.
Presumed
while
innocent,
she is a
though.
paraplegic, the Sheriff's Department has clearly articulated that they have the means to transport her to court safely, to send a clean and well-staffed wheelchair van to Tewksbury to pick her up, to have a nurse present, to bring her back and bring her into court, just the same way any other person who's held without bail on a murder case is brought into court and should be brought into court. Notwithstanding her issues in terms of transportation and needing a wheelchair, she should be treated the same as any other defendant and not be given special treatment. She should be given accommodations due to her condition, but not special treatment. And she has those accommodations. You heard from Attorney Kenny that they spoke to the medical staff at Tewksbury. She's able to move herself in her wheelchair. She's able to transfer herself in and out of her wheelchair. She may need some slight assistance during certain personal care situations, but other than that, she's self-sufficient. So there really should be no other special treatment other than getting her here safely. And
it's a stretch to say someone in a wheelchair is self-sufficient. They're not self-sufficient. My daughter uses a wheelchair.
That
she can walk
any
sometimes.
Other, accommodations requested by defense are unnecessary and would just be special treatment for no reason.
All right. I'm going to, first off, I want to thank everybody for giving me the information, because this is not something that I had, really right at the tip of my finger. So it's very helpful. I'm not going to make a decision right now as to how the defendant is brought into court. I'm going to draft an order, and then I will probably send it to all the parties. And then it may be something that we want to have a further hearing on, a further date. And then it may be something that we may want to, even before the trial date.
Yeah, that was disingenuous from that woman from the county to say she's self-sufficient.
Clancy come in for one of the hearings or so, just so that if there's something that I haven't thought of, we can kind of see that, so that when we do get to the trial date, it's as smooth as we can make it. So that's what I'm inclined to do here, is just come up with a draft order for transportation, and then we can kind of address it. Because we know now that we've got a little bit more time than we thought, because of my moving the case into July. So that's what I'm going to do in that. Anything else we need to address today? No. Attorney Reddington?
No, thank you.
Attorney Sprague?
No, Your Honor.
All right. So at this point, we've got that next date in January. I'll get a draft order.
Okay, that will do it. Kevin Reddington, he's quite the attorney, so we'll be seeing a lot of him when this does go to trial. Let's get a break. We're going to shift gears when we come back. We're heading to the state of Georgia, the stranger home invasion murder trial for Matthew.
I said that's a Lindsay Clancy case, so that part's done. The Brian Walshe stuff is still on the ridiculous, colorful screen at the moment. So there's no movement there in that right now. No, Duxbury, Plymouth County. She was Duxbury, Plymouth County. So I mean, I think it was, a little disingenuous of the county to say, or the sheriff's office, whatever they are, the DOC, let's just call it the damn Department of Correction, because essentially that's what it is. To say, oh, she's self-sufficient, she might need help getting in and out of the wheelchair, but nobody who uses a wheelchair is fucking self-sufficient. That's just absurd and ridiculous. And that was definitely disingenuous. I don't know why they want her so bad, or they want to transport her so bad. Doesn't really matter for me who transports her or why. I know there's a date coming up. I'll have to check on what date that it is, but I do know there's a date coming up for that. Plymouth County, not Plymouth, Plymouth County. So it happened in Duxbury, Massachusetts, which is in Plymouth County. I think, Kevin Reddington made some valid points. The American with Disabilities Act supersedes any other law. It's a federal law for people with disabilities. And yes, she should get an accommodation. But that accommodation, he said, where she's safe and comfortable, she doesn't have to be comfortable. No inmate is comfortable. Okay. She has to be safe, but she doesn't have to be comfortable. I think the judge needs to do something in the middle. I think I would go with his idea of the ambulance. And if the county is really that, flummoxed about it, they can send a chase car, yeah, Plymouth County. So it happened in Duxbury, Massachusetts. But I get where they wouldn't want to use a van, those vans, and with guards and the whole rigmarole. I mean, she's in a wheelchair. She's paraplegic, right? She's not going to get up and run away, right? I don't think there's anything wrong with having her brought in an ambulance. There's no point for leg shackles since she can't move her legs. She can't run away, right? So she is held without bail. She's at Tewksbury Hospital instead of a jail because of her condition. So she's already essentially getting better treatment than what most people get. I agree with him in the aspect that the Shattuck is deplorable. No one should have to get their medical care there. Nobody should have to go there, period. It should be shut down. It should have been shut down a long time ago. And she was on Suicide Watch. I don't know if she still is. That has to be reassessed like every couple hours. Even in the jail, we had to reassess that every 2 hours. Every 2. The doctors are supposed to reassess it every 2 hours. So I don't know if she's still on that watch. Not that I know of. I mean, they haven't released any medical or anything like that that would tell us if she had been diagnosed with anything or what she would be diagnosed with. I do know she was on at least a dozen medications or more at one point, which is crazy. I know that she was seeking active help for the postpartum. She had therapy, she had doctors, she had, been expressing to her husband, to them, all of this stuff that was going on. So it wasn't for a lack of care, I guess. It's a heartbreaking case in general. I'm not, the second floor window. Yep. Her husband was out. I agree that she probably should have, right? In hindsight. And that's the other thing is people don't realize that it takes like 6 to 8 weeks for meds to work. I just think that's far too long. Nobody has, especially in a mental health scenario, you don't have 6 to 8 weeks or 12 weeks for meds to work. At that point, you should be inpatient until they work because it's dangerous, I think it's not for a lack of the family. The family got her all the help they could need. Let me just put some context into our laws here in Massachusetts. There is one law called a Section 12, right? Section 12 would be a mental health hold. It can only hold you for up to a total of 72 hours. I can count on one hand how many times someone has actually been held for the full 72 hours. Usually they're let go within the first 6 to 10 hours, which is sad, but here's what happens. They go to the hospital and they tell the EMTs or hospital they want to harm themselves or others. They get held or an order is put in to hold them on a Section 12 and they get brought into a hospital, right? The doctors come back around every couple hours. After about 6 hours, the doctors come back in and say, do you still want to hurt yourself? If you still want to hurt yourself, we're going to have to keep you here. If you don't still want to hurt yourself, we can figure out how to let you go home. And basically what happens is the people who still want to hurt themselves or other people will just say, nope, you're right. I was just really upset. I don't want to hurt myself anymore. And boom, they're let right out. Even if they do still want to hurt themselves, all they have to say is the magic words that they don't want to. And it's it. And that's it. It's over, right? Section 12 is over. And the problem is a lot of times people know enough to know that if they really do want to hurt themselves, all they have to say is they really don't want to, and they can just be let go and they can try again. And that's half the problem with our mental health issues here in Mass is 72 hours is the maximum. Yeah, see, that's not legal. That's not legal. 72 hours is the maximum on a Section 12, right? 72. That's 3 days. And it almost never gets to the 3 days. It does happen, but it's not often, right? It's not often. Usually it's a day, 6 hours, 10 hours. The most time usually is between 24 to 36 hours. And most times people are let go in the first 6 to 10. That's, a Section 35, right, on the other hand, is for addiction. And that's 21 to 90 days of a holding. I would think that mental health should have the same as a Section 35. Section 35 being for you're a danger to yourself or others by using drugs or alcohol. And so your Section 35. That should be the same for a mental health section, in my opinion. A series, girl, I could do years of shows on how broken our mental health system is. I worked in it, in a prison for the criminally insane for years. It's broken. It's extremely, extremely broken. They just rinse and repeat, right? We had people in the jail who were on the same medications for 4 or 5 years, and they weren't getting any better because they're on the same goddamn medications. To get that doctor to change the medication, with the nurses advocating, with us advocating, they just didn't want to. They weren't trying new things with these people. They weren't trying new medications. It was, oh no, we'll just up the dose. Well, the med's not working, clearly. Their behavior is the same, right? So upping the medication isn't always the answer. And even that was like pulling teeth to get them to do. Most likely we want them to change it up, try something else, right? And they don't want to. They just refuse. The doctors don't care. Every script they write, they get paid for. But when they do X, Y, or Z, then here comes the DEA asking why they changed this many people's medications. So this is a problem with our healthcare system in general, right? The doctors don't want to change the meds because they don't want to have to deal with the hassle of them having questions about why. And then, you have hundreds of inmates on medications that are just not working and haven't worked in years, and they're not getting actual treatment that they need. I watched it. I made reports about it. I talked to lawyers about it because I thought it was wrong and inhumane. Talked to them about, I filed reports with the state. I complained to the state, right? About many, many things. I mean, it's broken. It's broken. It's so broken. So broken. So my suicide, something I know a lot about. Again, my dad, who adopted me when I was just 4 or 5, committed suicide. And he resides in this necklace, as most of you know. And suicide, mental health isn't a joke, right? It's serious business. And we don't have enough help out there or enough actual things that can help people other than SSRIs, in my opinion. I can't even take SSRIs. They have the reverse effect on me. And if I'm that way, how many other people have that same problem, right? So they say SSRIs are supposed to be the best things to work for mental health. I highly disagree with that statement. I honestly think they're more harmful. But hey, what do I know? Just a person, It is a strategic plan by his attorneys, definitely. I just don't know how well it's actually going to work for them, to be honest, Yeah, well, that and it's there for the insurance companies to take your money, the doctors to take your money, and the insurance money, and to, more money, more money, more money, more money, more money, more money. Everything goes back to money. Follow the money, okay? Everything is about money. Every fucking thing. Our healthcare system, the whole nonsensical bullshit, all of it. If they, write this one med might be $1,000 per pill. If they change the med and you're asking them to change the med, well, that med might only be, $50 a pill. So they're not going to do that. They're just going to up the amount, up the ante, right? Like, come on. Carol would like everybody to hit that like button, please. It is, but we have so many ways to treat it, right? Music therapy is an amazing thing, right? Water therapy, an amazing thing. I have CPTSD, so I've tried a multitude of therapies, from sort of delving into trauma-based therapy. And I think anybody with mental health should have some trauma-based therapy, right? It's also about having the right therapist and psychologist and psychiatrist. If you don't have the right one and you don't jive with that one, and that one just says, well, how do you feel about that? I can't deal with a therapist that just asks me how I feel about that. That's not, in my opinion, not sorry, that's not a real therapist. I don't need you to ask me how I feel about that. I need viable solutions, right? Viable options or problem solving things, not, well, how does that make you feel? Or how do you feel about that? I've been with the same therapist for 5, almost 6 years now. You know? Yeah, me too. They can give you anxiety. They can give you suicidal ideation, homicidal ideation from taking an SSRI. And again, informed consent, they're supposed to tell you all these things, although they don't, you know, they don't. They prescribe it. You go to the pharmacy, and unless you stop the pharmacist and say, hey, what are the, effects of this? Or you stop the doctor and you say, what are the effects of this? They'll say, oh, I don't know. You can, look at it on the pharmacy. And then they give you a paper that lists some, but not all of them, if you even read that part, because it's in very small writing and attached to the paper that they give you when they give you your prescription. But unless you specifically seek that information out, it's not given to you ahead of time. And that's good that it works for you. Some people it does. I'm not one of them, unfortunately, My therapist deserves a raise too, girl. Listen. Well, that's the other problem, right? They go along with whatever the doctor recommends. And when the doctor says, oh, well, it's just not working yet, we'll just up the dose. A lot of people actually believe that's the case. You know your body best. If your body is saying, hey, this isn't working, or upping, and they say, oh, we're just going to up the dose, and your brain automatically goes, that's not going to do anything, that needs to come out of your mouth. You need to say, I don't want to do that. Because you have to take control as well. I don't want to do that. That's not going to do it. We're going to need to try something else. And that's another problem, is people advocating for themselves. And also we have doctors that will get mad when you advocate for yourself, or your body better than them. They will actually try to gaslight you, and it happens to a lot more women than it does men. But if you say, no, that's not it, there's something else wrong, I know there's something else wrong, they'll just gaslight you, right? No, there isn't. All your blood tests are fine. Newsflash, not everything shows up on a blood test. I dealt with this firsthand and got a new doctor. And finally, when I got a new doctor, my doctor was like, I promise you, we are going to figure out what is going on with you. And my doctors did more than, shocker, they did more than blood tests. I had MRIs, I had CT scans, and they figured it out, right? But I knew, my body knew something was wrong. The doctor wasn't listening. They all know your blood tests are fine, you're fine. That I love hearing that. Or you go to the ER when something's wrong and they're like, oh, we ran all your blood tests and your urine and everything's fine there, so you're good, off you go. Well, they just charged you thousands and thousands of dollars in the ER and got you out the door so they could get somebody in. It no longer is about how actually to figure out what's going on with you and treat what's going on with you. It's about getting someone in and someone out, someone in and someone out as fast as humanly possible. Money in, money in, money in, right? And it's unfortunate because we're leaving people suffering. You go in, you don't know what's wrong with you. You're expecting the doctors to figure it out, right? You go to the ER, you figure out, you tell them all the symptoms. They test your blood. They don't find it in your blood. And they go, oh, we didn't find it in your blood. So, follow up with your PCP. Well, what happens if you don't have a PCP? What happens if you're visiting, on vacation, not around? Don't drive. So finding a PCP not only would be, or live in a rural area. That's why you're at the hospital, right? Or your PCP is closed. It's 2 a.m. That's why you're at the hospital, because it's an emergency and you don't know what the hell's going on with your body. But the doctors are saying, oh, your blood work's fine. You're fine. Off you go. We don't know what's wrong with you. Follow up with your PCP. Your PCP is going to tell you, well, we don't know. That was the hospital's job to use all their machines to figure it the goddamn fuck out. And they don't. They don't, because they don't care. If it's not in your blood work and it's not in your urine work, they really don't care. And it's not like an obvious break. They're just like, all right, off you go. Here's some ibuprofen. Bye. Hey, you can call me anytime, my friend. I'm like a second therapist to people. I always tell them, if you don't have a therapist, get a friend. Get a friend. It's just as good to vent to someone, anyone, right? Venting needs to happen whether you have a therapist or not. Every person should vent, right? I don't care who it is. And you're more than welcome to call me. Yep, that's why I say advocate for yourself, Listen, that's okay. Usually they only give you 15 minutes and it's like, what can I tell you in 15 minutes? you know, for your psychiatrist. All they really want to know is, do you need a refill on your meds? Cool, great. You're wonderful, great. You're going to continue on, great. Bye. That's usually how it works with a psychiatrist. They don't want to talk to you for more than 15 minutes. They want to just write, and they can't write the refills on your prescriptions without actually having an appointment with you, or the DEA will come and, you know, take their license and throw them in jail. So, you know, it is terrifying. It's absolutely fucking terrifying. You know, it's absolutely terrifying. It's not in your blood work. That's why, because there's more than just blood work that will show something that's wrong, right? I have long haul COVID. So I have myocarditis, tinnitus, fibromyalgia, psoriasis, arthritis, liver problems I was born with. I have POTS, chronic fatigue. Like, the list goes on and on and on and fucking on. I'm in chronic pain 24/7. And a lot of this couldn't be figured out right away. Why? Because it simply wasn't in my blood, or whatever test they were running wasn't in those tests. Right. But I pushed because I was like, I am in pain. I've never been in pain before. I have this going on. I never had this going on before. This is happening with my body. This has never happened before. And, you know, sometimes the doctor will say, well, bodies just do funny things. No, they don't. When something's happening, they're telling you something's happening. It's your job to figure out what the hell's going on, you know? Practice holding your pee. That's weird. Why would anybody do that? That's another thing. Some people's PCPs, they shut down the whole system. It shuts down, and then what? And then everyone's offices are full and there's nowhere to go. And, you know, X-ray, CT scan, you can also ask for those things, right? If you feel like there's something going on that it might, like, you can ask for those things and push for them. And if they say no, ask them for that in writing. Be like, I am asking for this test for this reason. If you would like to deny me that test, because what'll happen is, instead of them denying you, they'll just say, oh, we don't think you need that. There's a big difference between saying we don't think you need that and saying no. That's how they get away with sort of deterring people from wanting to do it versus, you know what I mean? We don't think you need that. Oh, well, I think I do. So I would like to have it. And if you would like to deny me that, then I would like it in writing, please. And watch how fast they schedule it. I know where they're taking new patients, and there should be one in your area. I'll text it to you later. That's they definitely do sometimes. Yeah. Yeah. No one wants to feel like a zombie or numb, you know? I don't mind, you know, because I have to be tested again for MS. So it is what it is. It is hard nowadays to find good medical care or a doctor that's not going to gaslight you. Ego is a real thing. You see it a lot with cops, but you see it sometimes with doctors too, where it's like, okay, cool. I know that this must be the thing that's wrong with me or something related to it. And then the doctor doesn't agree, right? Then the results came back and you were right. Well, they don't like when you could have been right over then because they're the doctor, right? So it's like a battle of an ego at that point. And it's like, I don't need a fucking ego. I need you to just listen. I need you to listen, you know? ECT is literally illegal unless you are at one specific school that they use it at in the state of Massachusetts. It is banned everywhere in the country. You cannot use electronic shock on anyone. Except for apparently, you know, at the JRC, which they've been trying to get that banned for years. Exactly. Ibuprofen and living with it. My pain's that bad that I live with it. It sucks, but I live with it, you know? It's unfortunate. And I always say you shouldn't have to be an asshole to get what you're, you know, should already have. Like, I shouldn't have to be an asshole to get an answer. I shouldn't have to be an asshole to get my insurance company to pay for a med that my doctor ordered, right? It's standard. It should have already been approved. I shouldn't have to be an ass to get, but unfortunately, sometimes that's the case, you know? See, that's the other thing. If you have a good doctor and it's further away, I'd rather drive further away or take an Uber further away for a good doctor than a shitty one nearby. You know what I mean? Well, that's what we do is just live with it at this point. You know, I live with the pain. There's nothing else I can do about it. You know, ibuprofen, hot heat. That's about it, you know? Girl, I hadn't been either until I got all these health issues after I had COVID. I hadn't needed to, you know? That's the other thing. It is a frustrating process to try to find it. You are right. Yeah, that should never happen. And if it does happen, you should definitely report it. You know? Me too. I'm blessed. My doctor is amazing. He's great. He's very thorough and he gets the answers, you know, and he listens. That's a good quality. All right. This stuff is over and I'm starving like a hostage. I've been here 3 hours. I love your stinking faces. I will see you guys in the morning. This isn't coming back on anytime soon. They're doing all the jury stuff. Usually it's always just the hearing in the morning, maybe a little thing after lunchtime. But I love your stinking faces. And if you'd like to join the channel and you're catching the restream of this, there are a bunch of different ways to do so. You know how to do it. All the information is on the screen. I love y'all, and I will see y'all in the morning.